Okay. All right. Thank you. Bye.
Oh, yeah, there you go.
Good morning, everybody.
Good morning.
Carrie, I want to make sure, good morning, everybody. We've had again, some technical issues, but we have a very able staff able to navigate us through this. So thank you for your patience. So if we can go ahead and get started, I believe we are good to go. So at this time, I will call to order the Yamhill County Board of Commissioners formal, informal session. Here we go. For March 11th, 2021, and we'll start with a flag salute. Commissioner Berschauer, would you please lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic
for
for
which
which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Thank you, everybody. And I want to welcome everybody who is online joining us this morning. We do have a land use hearing and we will be facilitating that online as well. So appreciate everybody being here. At this time, we'll begin with a calendar session. Commissioners, anything to add to our joint calendar?
Chair, I don't have anything at this time.
Thank you all. Next, we will move on to.
Same here, Chair.
Sorry, go ahead, Commissioner.
Sorry, I said same here.
Okay, thank you. We'll move on to public comment, and we have received public comments via email. Everybody's had a chance to read those. On to item E, our work session. This time is reserved for topics of discussion. We have no work sessions. We have no department updates. We do have a consent agenda. Ken.
I just wanted to quickly note that there was some miscommunication or some confusion around the work session agenda for this week. And I just wanted to again state for the meeting that the work session in which we've received public comment on with regards to the trail corridor work session is scheduled for next Thursday. It was not scheduled for today. And so I just there's going to be public comment that was submitted because there was information that went out that the work session was scheduled for today, but it was in fact scheduled for next week.
Yes, thank you. Made note of that to keep those comments for next week's discussion. So thank you all. And so at this time, I'll entertain a motion to approve the consent agenda.
I move that we approve the consent agenda as presented.
Thank you, Commissioner. We have a motion to approve. Any further discussion? Hearing none, all those in favor signify by saying aye. Aye. Motion passes. On to old business, which is item H1, consideration of adopting the Yamhill County Second Amendment Sanctuary Ordinance, continued from March 4th, continued from the week before that, continued from the week before that. And I do want to say there are several versions in the agenda packet for this week. And one of the things that I offered up was I sent a copy of the Sherman County Second Amendment Sanctuary Ordinance to the commissioners to look at. I had received a copy of that.
Chair?
Yes.
Really quick, I think we skipped item H1, which was the opt-in, opt-out for the vertical housing, unless it's been changed. But
I have on my version, H1 is the Second Amendment Sanctuary Ordinance.
oh, okay. We have a different version. I'm not sure.
That's item H2 is the
Okay.
vertical opt-out?
Okay. Just
Okay.
wanted to check. Thank you.
We'll get to that. Thank you. So I had received a copy of Sherman County Second Amendment Sanctuary Ordinance, which was considerably more streamlined than the one we had been using. And I contacted the judge there, Judge Joe DeBolsis of the Sherman County Court, and asked him how this whole thing came to be. And what Judge DeBolsis told me was that his undersheriff, which was James Burgett, had presented this to their court and asked them to pass it. That iteration was sent to a detective, Travis West, who I spoke with and asked him a little bit about how this came to be. And it was at the behest of the undersheriff, taking a look at what was going to be coming out of the Oregon legislature in terms of gun control laws, and wanted this to get before the commissioners, the court there. So that is why I added this particular version to our packet. And I also want to add that at the AOC Public Safety Committee meeting, we had 87 people at that meeting. It's usually just a handful of people. So people from around the state voted in opposition of that one particular bill, Senate Bill 554, which is working its way through the legislature, of great concern to concealed handgun license owners. And that went to the legislative committee, and the legislative committee voted to oppose this bill. Typically, AOC does not take a position on gun bills, but the opposition was fierce and people are concerned. And so AOC has taken a position to oppose this. I say that as sort of a prologue to why we're finding ourselves in a position of having to even consider, either at the federal level, nullification laws, which are working their way through or have been passed in a number of state legislatures to nullify federal gun control laws, and those that are working their way through our county commissions, which have been passed, and that has to do with Second Amendment preservation ordinances or Second Amendment sanctuary ordinances. So the reason I bring that to you is because it is a tool that we have to, at the point when the wolves are at the door, I mean, they're no longer howling in the distance. There are significant assaults on the Second Amendment, and that's why I feel strongly about this. I brought the Sherman County version to you, and that is up for discussion, so I'll let you go from there. Commissioner Berschauer, I know that you had your own version initially.
Thank you, Chair. Yes, so I submitted a revised version. We're calling it version 3. That should have been in the packet. And there were very few changes to it, but it addresses some of the issues that the sheriff brought up last time in terms of his, terms like prosecutorial and those kinds of things. So that was removed. Commissioner Kula brought up a concern about the vagueness of one of the sections, but when I read through it again, I really think that the exceptions specify and make that more clear. And that was something that the attorney Tyler said that is typical for these types of things where you start out broad and then you narrow the focus. There were a couple things that Christian had mentioned in section 3 that I did change. So you should see those on the version 3. They should be redlined. That just came through this morning, I think, with the redline version. But when I saw the Sherman County one put on the agenda, I think it is much simpler. So that's nice. I think it's going to take some work to kind of try and marry the two, because the Sherman County one doesn't have penalties necessarily in it. It's a little bit more broad. It just focuses on the prohibitions. And so I think it's worth trying to kind of combine the two, but I think it's going to take some massaging to try and do that, to make it simpler, but then also include the key pieces of the version 3 that we were looking at last time.
So what if we were to, my suggestion was to add the penalties, I believe those were in section 4 of our original version, add those to the Sherman County ordinance. Does that cover what the concerns were from last discussion?
Chair, I'm just reading through the Sherman County one now as well in more detail. So I'm here, but I'm also reading at the same time. So feel free to continue with.
So originally, it was just basically adding the provisions of which were section 4, which are the penalties, adding those to the Sherman County version. But if that doesn't answer some of the concerns we've discussed previous to this, then I'll just sort of just go ahead and continue on with the discussion of the version you had. Commissioner Kula?
Yeah, can I get, Christian had, some very specific concerns about the previous editions of this ordinance, and I'm curious if he has any thoughts on the Sherman County version.
Thank you. Christian?
Thanks. Yeah, I'm just kind of reading through and looking at them side by side. One question I have, we had talked at length last week about how the draft we were considering then was limited to apply only to employees or officials or agents of Yamhill County. I don't see a similar sort of limitation in the Sherman County document. So that's one question I have. When it says no law enforcement agency, office, or department, are we talking county only? Are we talking local municipalities, state or federal law enforcement? And when we look at office or department, are we expanding it beyond simply your law enforcement offices to include other offices or departments of the county or the state or municipalities? So that's one question that I have. It also appears to me that these proposed prohibitions to enforcement would prohibit enforcement of not only future firearms related regulations, laws, rules that might be passed, but would apply to all existing local, state, federal firearms rules, regulations, which I think puts us squarely back into the dilemma that we discussed last week about preemption. And I know there was a lot of discussion about regulation versus enforcement. But with all respect to Mr. Smith, when I review this, I have a hard time seeing a prohibition to enforce being anything other than an attempt to regulate. Even if it is only an attempt to regulate at the local level, that's just my analysis of this so far. So I think that's still a question that I have in my mind. And then I noticed as drafted or as adopted, the Sherman County ordinance has no penalties. I don't know if that was by design, and whether or not they thought through or considered what they might do in the event of a violation of the ordinance. I don't know how they would go about enforcing this ordinance without some sort of an additional provision about what the penalties are. And perhaps, again, not knowing how they were approaching this may have been something that they viewed, as I understand some other jurisdictions have, as a sort of symbolic expression of opposition to the legislation that's working its way through Salem and through Washington, D.C., rather than something that they would particularly see them going forward with and actually enforcing. And we've talked about some of those dynamics in the past as well. So that's sort of my initial thoughts on it. I'd be curious to hear from others or from the sheriff or from the DA.
Thank you. Before we get to Commissioner Berschauer, I just wanted to answer the question you asked. Why did they specifically leave out the penalty section? And when I spoke to Detective West, I said, why don't you have that in there? He said, because it wouldn't happen here and we're not concerned about it and it's working fine, which was interesting, but that's Sherman County and it's not Yamhill County. Nevertheless, I appreciated the sentiment, meaning that they typically understand that no law enforcement there would be violating this ordinance. So that was the response I get as to why they left the penalty section out. Commissioner Bershauer?
Thank you, Chair. That kind of clears up a little bit because I was wondering because this is a resolution, which I don't know if in a county court, if that's technically different from an ordinance, but it seems like an ordinance is much more, carries more weight, but maybe I'm wrong. Is that, Christian, is that correct?
It depends on which definition you're applying, right? Oftentimes in statute, they'll mandate that a local government or a municipality or a district take action through the form of a resolution. We viewed those as being equivalent to what we refer to as board orders. Under our policies ordinance, we have resolutions, which we generally reserve for sort of proclamations of general interest in the county, declaring something, Bill Gilly Day or National Awareness of Child Abuse Week, things like that. Board orders we utilize for issues of county concern that are not specifically legislative, and then ordinances are used for local legislation. It appears that while Sherman County calls it a resolution, I would expect that this is similar to either what we would say is a board order or even an ordinance, but I'd have to know more about exactly how they model their documents.
Thank you. Commissioner Bershauer, did you want to have further discussion on what your recommendation was for the version that you're proposing?
Thank you, Chair. So if the sentiment is to try and simplify the ordinance by using the Sherman County version, I think that's fine. I guess the part that I look at is, if we're going to imply the penalties, the penalty section is pretty extensive. And I think that's, by design, it should be. So I'm not sure we're going to get into any sort of simplification if we do add penalties in there. And I'm also curious about private cause of action. Is that something that that you were thinking should be included in penalties, with penalties, or are we thinking that it just needs to be removed?
No, and I'll just say that I just offered this as an option for a discussion point to say, hey, listen, here's a simplified version. Seems to be working. It's been in effect for a year, exactly a year and some months. So I offered it as a discussion point. And if we are interested in going the route perhaps of a more detailed version, I just wanted that for a discussion point. Thank you. Yes, Commissioner.
Thank you, Chair. So I think at this point, it would be interesting to get feedback on the Sherman County one from the sheriff and the DA, just for a point of reference. And then I can take another look at version 3 just to make sure that, everything is covered that was brought up last time. So at this point, I think I'll propose that we move it again. Unfortunately, we keep dragging this on, but this is good. This is part of the process that's necessary. So I think that's where I'm at this point.
So I know our sheriff is joining us by phone. Sheriff Svensson?
I think we need to promote him.
Okay.
They're on it.
There we go. Sheriff, welcome.
And then, Chair, I'd be curious if DA Barry has had a chance to look at the Sherman County one as well.
Yes, right. We'll weigh in with both our DA and our sheriff. So there we go. Looks like
Okay.
Our sheriff is off mute. Thank you, Sheriff Svensson.
Yeah.
Were you able
No, it's all right. Well, there's about 4 different hoops I had to jump through to be able to talk. That's the hardest anyone has ever done to keep me quiet.
Commissioner Bershauer is asking if you had an opportunity to look at the Sherman County version of the Second Amendment sanctuary/resolution ordinance and what your thoughts were.
Yeah, so I took a gander at it last night and was reviewing it a little bit more this morning. And I've reached out to Sheriff Lowry of Sherman County to kind of see how, my big piece has always been, as I've said before, I don't agree with any of these new laws that are coming down, and that is not going to be a priority of my office in some of these areas. But there are going to be times where my staff are going to have to enforce some of these new laws, and it's when bad people are doing bad things. And I'm just curious how they get around that in Sherman County, because I know Sheriff Lowry really well. If there was a perfect scenario and a perfect case where a bad person did a bad thing and they violated, let's say, the personal transfer for the gun ownership on the background piece, and had that actually prevented the bad thing from happening, I could see them wanting to move forward with that prosecution, because that was what the intent of that law was. But the concept of just going out and randomly investigating what I would consider law-abiding citizens for further restrictions on their gun rights, that is not a position that I would be taking, and that's not a position I'm sure he takes. So I'm just kind of curious, with the way that law is set, or that resolution is put in place, how he can get around that part, because it doesn't seem to clarify very clearly in that Sherman County on that particular piece. But that was my only major concern in that particular draft. I do like how short and sweet it is, because I'm all about keeping things as short as possible. But I do think some of the additional revisions that were made in the draft that Commissioner Bershauer sent out from last week, I think basically address that one concern that I would have, is if we needed to enforce it moving forward, we have the ability to under that section.
Sheriff, can I jump in here for a moment? I wanted to address your concern about that. In Section 1 of the Sherman County Second Amendment Preservation Ordinance, Sanctuary Ordinance, it says, no law enforcement agency or personnel, for the purpose of investigating, detecting, apprehending, or incarcerating persons whose only violation of the law is that they carry or possess or transfer a firearm. So I think this is clear that it's not protecting criminal behavior. It's protecting those who explicitly have not committed a criminal act.
Yeah, no, and I did see that differentiation of, we're not going out and specifically investigating. I think the question is going to come down to, I keep referring to the private transfer one, because that's the only one that I can think of that we would ever come close to actually filing on. Is, bad person wants to go commit a crime, and they talk to their buddy, and they buy a gun from their buddy, and their buddy knows that they should have done this background, and had they done that background check, the gun transfer would not have taken place. The charge of that particular violation could fall not only on the bad person that did the bad crime, but also the person who should have known that they shouldn't have given that gun to that bad person. And that particular piece would be, may be the only crime that particular person committed, which would prohibit in this particular case, unless we're considering it one whole large case and it's the totality of the circumstances with multiple suspects. But yeah, it's I like the concept of the way they've worded it, because it's reemphasizing that that's not what my staff is going to take up as a priority on their daily function, is going out and specifically identifying people violating these new laws to try to catch them in the act for that specific purpose. It's more of the holistic, global charge, I should say, in the big particular case. And so I'm not smart enough on the legal terms to determine whether or not that would be considered a specific violation, and maybe that's a question for Christian, if we have multiple suspects, but only one is being charged with one crime and it's that, and then the other person is being charged with multiple crimes, if that still applies, or if it's something that would be in violation of that particular resolution.
That's interesting because it says if the only violation of the law is that they transfer a firearm. So I guess that goes back to the question of the transfer, the person who transferred the firearm to someone who committed the crime didn't commit the crime, they transferred a firearm. But I guess that's a fine point of the law, but it does speak to a consideration. Commissioner Bershauer, did you have a question for the sheriff at this point?
Thank you, Chair. And this is for either Chair Starrett or the sheriff. When you were having these discussions, was there a specific, because I noticed this was signed in January of 2020, so presumably it was brought up in late 2019. Was there something that was the catalyst for them putting this forward, even though, you know, the understanding in Sherman County is that no one violates these rules, but was there something specific that they refer to as to why this was brought forward?
I was told that the undersheriff, whose name is James Burgett, had brought it to one of the detectives and had initiated it. So it was the undersheriff who initiated this and brought it to them. So whether there was a precipitating event, apparently he thought there was concern enough about Oregon gun laws that he brought it to his county commission, county court.
And then Chair, I think that my other point to make was in last week's discussion, the DA mentioned that, and this was under the example that we talked about, where somebody would be pulled over for speeding, but they were pulled over in the library and, you know, they were in possession, legally in possession, that he would have to have intent to file any charge. And I'm wondering if that satisfies some of these issues that the sheriff brought up, where you know, you're still having to jump over the hurdle of having intent. And so for the scenario that the sheriff just brought up, I'm not sure how you actually move something like this through, or where you would be prohibited from moving it through, because you have to have intent there, if that makes sense.
But this, as chair, in this case, aren't we referring to county employees and not to the person who might be charged with something? I mean, this isn't regarding people who aren't county employees. Isn't that correct? Or, I mean, right now it's global, but I think that your intent is for it to only apply to county employees.
Commissioner Bershauer, is that, I'm not understanding how your question dovetails with that.
Thank you, Chair. I think the version 3 is much more specific about making sure that the sheriff does not lose his discretion. I'm not sure I see that kind of language, and it's not necessarily as strong in the Sherman County one, even though it's simpler. But I think that what we have worked on until now specifically answers that concern, that the sheriff does not want to lose discretion. But on the flip side, the DA was saying that in order to prosecute, there needs to be intent there. And I remember making the comment, well, you're sort of making the argument against 554, but I guess my point is that I think that even though version 3 is more lengthy and more complicated, I actually think it addresses some of the concerns that have been brought up a little bit better than the Sherman County one.
And I don't disagree with you. I think that this really does cross T's and dot I's that the Sherman County one doesn't. I just brought it forward for us to look at and say this is another option, but it doesn't speak to some of our specific concerns. You're right. And it doesn't address a variety of the things that we've discussed. Commissioner Kula.
Sorry, Chair. I hope were you able to say your thought? Yeah. Okay. So in can you hear me?
Commissioner. You're
I'm actually
kind of
not seeing anything, so.
Okay.
garbled. Yeah.
Yeah, you're a little garbled, but go ahead.
Okay, thank you. So version 3 of Commissioner Burschauer's proposal, I think it's section H, where it addresses the sheriff's discretion. In reading that, I'm not a lawyer, but in reading section H or subsection H, it seems to essentially nullify every other thing that's in the document. And so I wonder whether there would be a way to simply say subsection H in a document in a maybe a more clear manner and remove the rest of the things. Because if you are granting the sheriff the discretion that he already has under state law, we should just say that and simplify it.
Commissioner Burschauer.
Thank you, Chair. So I think the point of section H is to address the sheriff's concerns, but it's also to put some sideboards around the sheriff. And, we have a fantastic sheriff now, but who knows what's going to happen in 20 years. So the intent is to put some sideboards around that so that any directives that the sheriff is using or any policies that he's enforcing technically should be written, but it also allows the county commissioners to have input into that process as well as the voters. The voters can have direct input into that. So that was kind of the point of section H. We removed the last line, starting with so long as said discretion and authority is exercised consistent with the legislative directives of this ordinance in response to one of the sheriff's concerns. But I don't think the way that it's written now undermines the purpose of the ordinance. I think it just simply states that the sheriff will be upfront about which policies he's enforcing, and also that the commissioners kind of have a seat at that legislative table, if you will.
Thank you, Commissioner. Commissioner Kula, does that answer your question?
I think it gets to the answer. I think that if we are intending to state through board order that we want to have a say in explicitly have a say in how the sheriff does his job, then we should just write that on a piece of paper and then have a discussion about that. Because I think that that's if that's truly a subsection H is truly the intent of this document, let's work on that instead. That's my proposal.
Thank you, Commissioner. I think sometimes obviously the sheriff is an elected position and the sheriff has the discretion and the sheriff has the attitude and has made it clear how he's going to enforce the law or not. And he's been very upfront about what laws he feels are unfair to law-abiding citizens. And I appreciate that. What I'm wondering is what is the juxtaposition of the governing body of a county in what's the nexus with another elected official? We have an elected official who's a district attorney, one who is an assessor, one who is a clerk, and one who is a sheriff. So how does that work? Other than in this capacity, we're saying we are not going to fund any type of enforcement of these laws. And I don't know, I think that's just our part in it, but you're right. The sheriff does have discretion. We have a good guy sheriff now, and there are some counties who don't have a good guy sheriff. And I want to make sure that we have those sideboards for those such times if we were to not have a sheriff like we have today. So maybe at this point, and you are a good guy sheriff. I just want you to know that.
No, I appreciate that, Chair. And I think the only thing I would say to that is I think that is the big topic that most people, try to bring up when it comes to these type of ordinances is that there is, in our level of government, there is a somewhat of a separation of power. There's the executive, the legislative, and the judicial branches, and they're designed for a very specific reason so that one can't necessarily overpower or dictate or control the other. But as you said, in this particular case, if you end up having a not so good guy sheriff come in, you're ultimately, their control, the level of control that you would have would be just not funding the office if they're going to continue to enforce things that you don't feel that they should be enforcing. And so I think that's the piece that in this particular case, having a little bit of that discretion left in there, at the end of the day, it's just further supporting the fact that we as a board are wanting us to go down this direction and not take our time and energy and money and to invest it in these areas unless the sheriff deems that it's very important. And if the sheriff deems that it was important, it's got to be because it was for a good reason.
Thank you, Sheriff. So maybe we should bring our district attorney in, Brad Berry. Hi, Brad. Thank you for being with us. And
Good morning.
Good morning. Appreciate your joining us once again. And so as far as the discussion goes, what we have now is we've had a discussion about a shortened version, which really doesn't have a lot of the specifics we've discussed in prior weeks. And looking at the version 3, that sample 3 that Commissioner Berschauer has been referencing.
And I've reviewed them. I reviewed actually the Sherman one initially, but then I've been going through it this morning more as you talked about it. And it does seem to, all the work done to get to version 3 to temper what you don't want to happen is ignored in the Sherman County version. So it does, and I haven't been party to these conversations until last week, but it seems to me the movement you've made would be totally canceled to adopt something similar to the Sherman County direct ordinance. So anyway, that's just addressing that. So I'm not sure where you want me to go from there, Chair. I have a couple of comments about version 3. Do you want me to go there?
Yes, please.
Okay. First, and I'm not sure if this is by design or just or not, but under section E, so it's 2.06 section E, it refers to district court. We don't have a district court in the state. There is a United States District Court, and if it's intended to refer to that, I think it should say that. District courts were eliminated, I don't know, 20 years ago maybe, or longer. So just throw that out. Then I think in the area under H, where I know there's been the conversation, a lot of conversation, I mentioned to you last week that I am a state elected official. And we had discussions about that, but I think it's going to be important to either have a similar paragraph related to my office or an acknowledgement that we are a state office operating under state rules, laws, and the like. Or we run into the same issue that I talked about last week. I have deputies who have authority that is granted to them by my authority, so it's a delegation of my authority. All my staff operate the same way. They get to do what they get to do because I do it, but they're technically county employees, and I think that really poses a problem. Unless there's an acknowledgement, a direct acknowledgement that the office is accepted.
So just a question for clarification, as far as discretion to prosecute something, that's something that lives within your office and under your discretion, correct?
It is.
Okay, I think that's important for us to acknowledge that, because that discretion is to prosecute something that might come under the category of what we're discussing here today. Christian?
If I may, we may be able to address this, and I want to put this out there just to see if it helps in this part of the conversation, because what Brad mentioned was something that I was going to bring up later. So I'm glad he said now. We would still need to somehow address the question we had last week about his office and his staff being able to work in this area. If you look at provision 2.06D, if this is primarily a forward-looking document in an attempt to limit enforceability of legislation that's currently working its way through Salem, could we revise subsection D to read that this ordinance does not prohibit Yamhill County, its employees and agents, which would then incorporate Brad's staff, from enforcing regulations dealing with the carrying and possession of concealed firearms, or dealing with firearms generally in effect as of March 2021. And we can massage the language around that to make sure that it encompasses what Brad Brad and the sheriff, this would apply to, would work to resolve some questions possibly for both of them, but would make it clear that we're not saying that they are prohibited from enforcing existing local, state, or federal gun laws in effect as of March of this year.
Commissioner Bershauer, does that get to what you're bringing up in terms of a consideration?
Thank you, Chair. Yeah, I mean, I can work with Christian on that particular piece. And I was actually curious. I didn't get to talk to any of the people that I reached out to, but in some of the counties that have SASOs, I was curious maybe if DA Barry had conversations with them about how they're navigating some of that with their employees as well. Was there any commentary on that? Because I wasn't able to reach the people I tried to reach.
If that question is to me, Commissioner, no, I haven't.
Okay.
And you guys mentioned last week that there were, I think Chair Starrett said there was like 16 counties who either had or were considering something like that, but I didn't know who they were. Obviously I know now, Sherman County, so other than, I think the sheriff had told me of a couple, including Josephine and
Harney.
I'm sorry?
Harney, Columbia, Umatilla, currently circulating Lane and Tillamook, but right now we have Harney, Josephine, Columbia, Umatilla, and we have another, I'm going to say about 8 that have a preservation ordinance. And Josephine County has a right to bear arms charter amendment, which was already enacted. So I do have a list I can send to you with the specifics.
That'd be great. But the short answer is, Commissioner Bershauer, no, I haven't reached out to others. And it's just for lack of knowledge. And candidly, I've been swamped. So spent all day yesterday up on a search. I've got police detectives coming here at 11:30. I pushed them back to 11:30 to debrief on the search. But I've been a little busy. But I did have time to go through your version 3, and I've highlighted it, and I had the concerns that I expressed.
Okay. Thank you. No, it's a valid concern about the employees, the deputy DAs. And so and I'll try and chase down some of those folks that I had reached out to, but it would be an interesting piece of information to see how they're navigating that too, because I'm sure it was a concern.
Sure.
Brad, any thoughts on whether or not that language would, at least for the time being, answer those questions for you? I mean, we still have to consider how we might still be in the preemption question if future legislation gets passed. But for the moment,
that seems to assist quite a bit. It's a little bit difficult from my perspective to give any law enforcement, and I'm picking on Tim now because he's included here by statement, they have discretion, but I would not. And so let's say, for example, they pass a bill that says you can't have magazines that hold over 20 rounds. Let's just throw something out there. And the sheriff gets the bad guy that he thinks is particularly bad, wants to use that with his discretion and arrest them for having a magazine that has 120 rounds. Then that gets referred to my office. And as written, I wouldn't have the discretion to file it. assuming for a moment that it overrides the state preemption. So although you give the sheriff the discretion, you're not giving the same discretion to the prosecuting body. So I wouldn't be able to, assuming this applies to me, I would not have the authority to have my staff file the document because it would be using county resources to do so.
Commissioner Bershauer?
Thank you, Chair. Doesn't the DA have discretion though? I read an article last night about the hullabaloo around the San Francisco DA, and there's a recall started against him because all of these reforms that he's putting into place that don't necessarily apply in other parts of the state. But is there not an inherent discretion already there that?
Yes, Commissioner, I have discretion to file or not file on anything. We do that based on the law. We do it on what we can prove. We have an obligation to seek justice. So it's not, I can prove crimes, but it may not be a just result. But my point is the way this is currently written, the sheriff could arrest somebody for having this oversized magazine. I would normally, but for the language of this ordinance, would have the discretion to file or not file. But this now says I wouldn't have that discretion. Arguably, my employees could not be involved in the filing of the 120 round magazine arrests that the sheriff was given discretion to enforce. Does that make sense?
Yes, but I think it technically, what you're saying is it would technically apply to your deputy DAs because you are employed by the state technically.
Well, yeah, that's a whole nother discussion. I think, Commissioner, when we're talking any resources, let me just go to the bare minimum. Let's say that I, as a state employee, said I want to file on it, and I have that discretion. I prepare the document, right? So now I'm using a county-paid computer to draft a document which will be printed on a county-paid printer with paper that the county paid for, and I will hand it to a staff person to file it with the court. And for the 5 minutes it takes them to get a copy in the file and walk it down to the court, we've now paid that employee 5 minutes of work and pay to do that. Those all involve county resources beyond my discretion, right? My discretion came into play with the decision, but all of that is ostensibly covered here saying that we couldn't do that. The sheriff can, his deputies, his staff can, because you have now allowed the discretion and his directive to be followed. But that same latitude is, at least not in writing here, is not granted to this office.
Okay, I think that's worth having a discussion about to see if something similar needs to be included with regard to the DA's office. But I would say that the same concern that we expressed about the sheriff, we have a great one now, we have a great DA now. What happens in 20 years if that changes? And cities across the country are seeing this push and pull right now. So the same concern exists, even though we are focused on, the level of enforcement with the sheriff's office. But I think it's worth looking at that and seeing if we need to add some language.
Thank you.
Thank you. Christian, before we get to you, Commissioner Kula, Christian, you were nodding your head. Can you respond to what the DA said?
Well, yeah, and maybe this would be a suggestion that would be better than amending 2.06D. We would simply add another subsection after H that would say essentially what H does now, but apply it to the DA's office, that the ordinance wouldn't apply to nor prohibit. And then we would add back in the prosecutorial, enforcement, or administrative discretion and authority of the district attorney to enforce firearms regulations. Brad, would that give you the discretion you think is now missing?
Actually, as I talked with the sheriff this morning briefly about this, my point was I think we need something similar that speaks directly to the DA's office, just to avoid confusion. The last thing I would want is one of my staff coming in and saying, "I'm not allowed to do this, Brad. What am I supposed to do?" And so, yes, I think that would probably, I don't know that you couldn't have both the DA and the sheriff in the same paragraph. And
Yeah, we
just
could.
acknowledging the discretion of arrest and prosecution that inherently exists.
Agreed. I think we could. I think we could have it in a single subsection, or we could have separate subsections.
Thank you for that. Commissioner Kula?
Yeah, sorry, Chair. I was, again, flipping back and forth. I was just reading that to see what it would look like. I guess to Commissioner Bershauer's comment about somebody in the future, an elected official that a future Board of Commissioners might disagree with. I thought that the sheriff actually said that pretty well. No offense, Sheriff, I'm giving you a shout out here, which is that he says, ultimately, your Board of Commissioners discretion comes down to whether or not you fund the work of the sheriff. And if you don't support your policies, you have the discretion to not fund their work. And I just want to note that he did give us an answer to that question for the future commissions.
Right, and that's really the only leverage that we have in terms of funding an office. Christian?
Yeah, one other thing to mention too, while we're trying to define the universe of county employees and departments that might come under this subsection, and this is maybe a question for Ken as well as Brad, is do we need to think about community justice? Retaining some discretion as well? And maybe we don't have to answer that right now, but wanted to make sure we had that out there and understood that that may be an area to consider when looking at this as well.
Christian, could you give us a for instance?
I don't know exactly the authority that your parole and probation officers have to enforce firearms laws. Maybe Brad could speak more directly to that, but that's kind of the scenario I was thinking.
Thank you. Brad?
It's probably, thank you, Commissioner. I think it's probably covered under your, the paragraph that says if there's a court order, that the court order will be followed because a condition of probation or supervision relates to an order of the court. So I think you have that parsed out already, which would authorize them to whatever regulations they're doing. So if a judge says you can't have a gun, then they're just enforcing the court's order.
Okay, perfect. Thank you.
Ken? You were raising your hand at one point, or does that cover it?
That covered it.
Okay, thank you. Thank you for that. So we have a couple of putting more of a fine point on several of these conditions and exceptions and more clarification. Christian, do you think that we have enough here for us to be able to get a final, or I won't say final, but a more revised version for next week to take a look at those, adding those in to the sample number 3 so that we could move this forward or not?
I think so, unless there are other questions that other members of the board have that we still need to work through. I have a couple of sort of housekeeping cleanup items that I can mention now or we can discuss later that I think would also need to be addressed. And I do have a couple of questions that I think Commissioner Bershauer and I could probably answer as we try to reconcile and put together a final draft. But yeah, I think we're pretty close.
Commissioner Kula, did you want to at this point weigh in on concerns that could be addressed in a further revision?
Thank you, Chair. I guess the first thing I would say is, do we have an adequate or sufficient answer to whether this violates the state statute around preemption, which was the concern that Christian brought up in the conversation with Councilor Smith last week. I don't have a clear sense of whether that's been answered. But I think ultimately I see the, 2.06 subsection H as being kind of the meat of this. And I would, I'm going to call again for us to consider a simplified resolution, board order, ordinance that really keys in on that. I think that there's a lot of other things here that distract both us and the public from what seems to be the important point to the majority of the Board of Commissioners. So those are my two things.
Okay, Christian, preemption?
Yeah, to the extent that's a question directed at me, that suggestion I made for subsection D, where we would limit this to, or it would not apply to existing local, state, or federal firearms regulations in effect as of March 2021. I think that largely addresses preemption of existing local, state, or federal firearms regulations. I think we can also get at some of the preemption concerns by the modifications we're talking about in subsection H, because again, law enforcement would retain their discretion to enforce those firearms regulations. And I'm sorry, that was the first part of the question. What was the second part?
I think that my two comments were about the substance of subsection H being really the primary purpose, and that calling that out would be, I think, the most useful approach. So it wasn't really a question for you. You answered my question.
Thank you. Commissioner Bershauer, did you want to respond to Commissioner Kula regarding the regarding that section?
Thank you, Chair. The section or just the comment about simplification?
Well, the comment about simplification in that one particular H, correct? Commissioner Kula? Is that the one that you referenced?
Yes, I think that subsection H, especially if we included DA Berry and other county employees who don't have discretion, right? I mean, DA Berry has discretion, sheriff has discretion, but there are other employees or other county staff who are not elected and therefore don't really have discretion. They have to do what their the rules, statutes, and their supervisors say. So expanding section H is what I would see as really being the value of this document, because then it gets to what Commissioner Bershauer is commenting on, which is the legislative function of the Board of Commissioners.
Thank you for that, Commissioner Kula. Commissioner Bershauer?
Thank you, Chair. I guess I would argue that it already adequately deals with the staff that falls under the sheriff, and then potentially the DA if we add in that language, because no one else follows those policies but the staff. So I'm not sure that we need to complicate it more. I think it's pretty clear. The actual discretion lies with the sheriff and the DA, but their policies are what pertain to their employees. So, and then in terms of just simplification, I think, we kind of went down that road with Sherman County, and there's a lot of things and there's a lot of work that we put into making sure that we're doing this the right way that's not included in more of a simplified version. So, I think I prefer something that has the input of all of these parties coming together. So that's my only comment.
Thank you, Commissioner. So we've addressed this for a number of weeks now, and I will agree with Commissioner Bershauer in terms of the detail and the fact that it's been reworked and revised. So at this point, my suggestion would be that we ask County Council to look at those revisions and bring to us next week the revisions that we addressed, especially in these sections that we've called out, and then take a look at that as being a version for us to consider voting on. Is that something that is agreeable? Do we have consensus for that? Commissioner Kula?
Thank you, Chair. I'm happy to see a more updated version.
Thank you. Appreciate that. Commissioner Bershauer?
Thank you, Chair. So just a point of clarification, if we bring forward the final, quote unquote, final version next week, Christian, technically it needs a first reading. Is that correct?
Well, yeah, there are two primary ways the board adopts ordinances. One is if it's a declared emergency and the vote is unanimous, it can take effect immediately. Absent a unanimous vote, yes, then there's a first reading and then a second reading at least 13 days after. And then if it's adopted after the second reading, it takes effect 90 days after that.
Okay, thank you. Yes, I am in favor of massaging one more time into a final version and then hopefully doing the first reading next week.
Thank you,
And-
Brad.
And what I, oh, sorry.
Oh, go ahead, Christian.
Well, I was just going to say, what I'll try and do is get the draft circulated, and obviously it's not a discussion that the full board can have prior to next week's meeting. But once I've circulated the draft, I'm happy to chat individually with each of you, and it'll go to Brad and the sheriff and Ken as well. I'm happy to speak individually to address any questions folks have prior to next Thursday's meeting.
Thank you, Christian. Brad?
The only thing under H, since I'm guessing that that'll be the kind of way that me and my office will be included in the discretion piece, is it intentional that it doesn't allow for oral directives? It talks about everything in writing, and the reason, I'm just thinking now pragmatically how things happen. So if a case were to come into the office and the deputy says, well, I've got this one XYZ, I'd be the one saying, we're not going to file on that, or yes, we are going to file on it, but I wouldn't create a written directive to do so. So I'm just trying to determine whether or not that was by design or by omission.
Good point. Christian?
Yeah, I think as it's currently drafted, I think the expectation would be that be in writing.
Is that something that would be burdensome, or is that typically not how it's done, Brad?
Sorry about that. It wouldn't let me unmute. Yeah, well, because each case is its own set of facts and its own, you look at the facts, you look at what you can prove, you look at the defendant, the potential for defendant. And since they're all individual, we make decisions every day based on a whole myriad of factors on every case. And this, at least arguably, could be said that I would have to prepare a written directive for each of those decisions. And that would be burdensome, yes.
Thank you, Brad. Commissioner Bershauer?
Thank you, Chair. No, I think that's a good point. I think it says written because if this passes, it then allows voters and commissioners to quote unquote legislate some of these policies. It gives that authority to do that. So in that case, you would want voters would just naturally have to do so in written form, and commissioners would have to do so in written form. But I can see where that would be problematic for the sheriff or the DA too. So I think we should look into adding oral directives for sure.
Thank you.
Thank you for that. Commissioner Kula?
Thank you. With regard to the oral versus written, I thought that the spirit of this was to provide very clear guardrails from the Board of Commissioners to other folks in their enforcement of laws, rules, policies. So I'm confused about why an oral would meet the spirit of that. And just for the record, I think that we should encourage our DA and our sheriff to use their discretion that they already have.
Thank you for that. Christian, do you see that adds another implication here that would be problematic by adding the word oral to decisions, written and oral directives?
So I think that I agree with what's been said in terms of it's important to ensure that the sheriff and the DA retain their discretion. At the moment, there's no requirement that they have written policies or directives in this area. So if the board is comfortable allowing them to exercise their discretion, then there may not be a need to require written administrative decisions, written directives, or written policies. But I believe Commissioner Bershauer may be viewing those types of written directives, policies, as a way for the board and citizens to better understand, or at least be able to observe, the way in which law enforcement intends to exercise its enforcement discretion. And if I'm wrong about that, Lindsay, please stop me. So that may be where she feels it would be of import to have something in writing. I think we could address it either way in the ordinance, but I want to make sure that in doing that, we're not losing a critical piece of what she was interested in.
Good point. Commissioner Bershauer.
Thank you, Chair. Yeah, that's a good point. Part of the purpose of this is for transparency. So I think I don't know, I think you could go either way. The voters, if they come forward and say, hey, you know, we don't agree with banning magazines that hold over 8, you know, that's a very specific written directive. And if it passes by a majority of the voters, then it's very clear, it's very transparent. If commissioners come forward and say, well, you know, we really don't want our sheriff enforcing, you know, magazine bans, I would assume that we would do so in written form. It wouldn't just be an oral directive. It would be in writing, so it's very transparent and clear. Does it change the way that the DA and the sheriff do things internally in their offices? Sure. Do we want to restrict that? I don't know. I am sort of, it's a good question. I don't know if that undermines the spirit of this, where we do want to be very transparent about what will be enforced here in the county and what won't be.
Thank you. Good point. Christian?
And if I'm understanding that correctly, I want to just point out that even if this ordinance is limited to laws or in effect in March of 2021, or it doesn't apply, to the extent there are future state laws, depending on how they're drafted, depending on their intent and their application, we could still, even with an ordinance like this on the books, we could still face a preemption challenge, or we might still have a preemption question. Because if, for example, there is a state law addressing magazine capacity, and then there is a local ordinance addressing that same magazine capacity, we could have, again, a preemption question. Not to focus again on Senate Bill 554, but that is an example of where the state has removed its exclusive preemption and given authority to local governments to act in certain ways. We might be able to, under this ordinance or with some amendments to this ordinance, address a situation like that, because we wouldn't have the state law preemption question. But in areas where the state retains its exclusive authority to legislate as it relates to firearms, we might still face those questions. We would face those questions going forward.
Can I just address real quickly? Something came to mind regarding Oregon state law. The county is now party to a lawsuit, and we are being sued because we followed Oregon state law, which had to do with the retaining the equity in a foreclosed property. So for instance, when we foreclose on a property, we take the back taxes and we distribute the rest to the taxing districts. I've long maintained that that's unconstitutional and it violates the takings clause of the Fifth Amendment. So now we are now being sued for that very thing, as are other counties in Oregon, for doing what the state of Oregon told us to do, which is patently, and the case is, the bearing is, and the foundation of this case is on the Constitution. So I think that this would not be a one-off. When you talk about preemption, we didn't go ahead and say, let's give people back the equity in their homes. We said, no, we've got to follow the state of Oregon's law, which now we're being sued over. So I think that should be a good lesson for us, that following unconstitutional laws doesn't give us cover at the end of the day. Commissioner
Right. And if, for example, we had passed a local ordinance that said, when we foreclose on a piece of property, we will give the excess proceeds back to the taxpayer. That would have been an example of the preemption issue that I'm discussing, right? We would have attempted to legislate at the local level in a way that is directly in conflict with an existing state law. You're right, that state law through the course of this litigation may be struck down. The court may may agree with the plaintiffs, in which case then we'll have to revisit how the state handles its property tax foreclosure proceeds, or the law might be upheld. We just don't know yet.
Thank you. Commissioner Kula.
I just wanted to note that DA Barry had a question.
Brad. You're on mute, Brad.
Commissioner Bershauer mentioned that about transparency, and I just wanted to remind everybody that our decisions to charge or not are right out there for everybody, right? So if we file a charging instrument, the decision made in the office is absolutely transparent. If we decline to file on one, that decision is absolutely transparent. So I absolutely concur that all the things we do and decisions we make here should be transparent to the voters. They have a right to know the decisions that I make, that I direct to be made, or that I allow to be made. And that should be all the time. But everything we do is absolutely transparent because the end decision is either the filing of a document, the conclusion of a case, or the declining of filing on something.
Thank you. Commissioner Bershauer.
Thank you, Chair. Thank you, Brad. That was a great point. I think when we added the language in this about March of 2021 and upholding laws prior to, in effect, we're drawing a line in the sand and saying, going forward, we have concern about what might come. In the case of 554, if that goes through, you will have directives from the sheriff. You will have directives from McMinnville, the chief of police in McMinnville, the chief of police in Newburgh. There's going to be different rules applied based on what they decide to do. So I think that when I say transparency, I'm a CHL holder, so I would want to know if the chief of police of McMinnville intends to hold me accountable for walking into City Hall while I'm carrying my firearm. I would want to know if the sheriff intends to do something, or Newburgh. So I guess that by transparency, that's what I mean. When you start having a patchwork of rules being forward about, hey, this is where we stand, this is what we will do and what we won't do. So when we're talking about written, I think it gives us a little bit more clarity, and it gives our residents and the people who visit Yamhill County a little bit more clarity on that, if it's written.
Thank you, Commissioner. So if nobody else has anything to add at this particular point, I'd like to suggest that we have consensus or not to ask Christian to look at those revisions and bring back a version for next week for us to look at. Is that agreeable?
I'm ready to see revisions and look at it again.
Thank you, Commissioner.
I still have concerns, but I'm always open to looking.
I appreciate that. Commissioner Bershauer?
Thank you, Chair. Yes, I think we work on revisions and get a copy out, hopefully a lot sooner than last time, and be prepared to do a first reading next week.
Thank you. And Christian, if you could share that with our district attorney and our sheriff when you have the revision, so that they'll have an idea of what we're looking at for next Thursday.
Yeah, no question. I will do that. And I saw Ken had his hand up. He may be thinking about the same procedural question that I am. And at the risk of saying something prematurely, I'll wait for him to weigh in.
I think I know what he's going to say. Am I right? You're going to say something about violating public meetings laws by having us all look at the same version, but couldn't we look at the same version?
That's not what I was going to say.
No. I was more going to, I'm sorry, my comments, and I don't know if it's the same, but my concerns are around kind of the version control and what's being circulated, because I know staff, we've been struggling, because that's why right now we have 4 different samples of documents in the packet. And I also want to ensure that we have sufficient time to upload it into the packet and have it readily available. And typically our deadline, for internally for department, anybody who brings something forward for board action, we try to 1 o'clock on Fridays to try to make sure that we get those packet, updated with the most current version that the board is going to be discussing or looking at. And that's both in the interests of making sure that we have the packet, but then also for the public to be able to also view the latest version. And I'm just wondering if the timeline, because some of the versions we've been getting them kind of late, and that we were trying to get them into the packet as quickly as possible. But I just wanted to throw that out for consideration on the timeline on how soon we think that there will be a revised version with the updates incorporated in the packet and readily available.
Thank you, Ken. Christian, is that something that is reasonable to expect?
I think we could have that by Friday, and then we would just agree that that's the version that would remain in the packet till Thursday. If revisions needed to be made following a discussion on Thursday, we could, depending on the substance of the revisions, as long as it's not materially rewriting the entire document, we could probably still go ahead and have the first reading, and then reflect those final revisions in the updated document that would then be discussed again a second time at the second reading prior to adoption.
Thank you, Christian. Does that sound agreeable to everybody? Ken?
Yeah, and the only thing that I would talk about, about the, we don't have the ability, the commissioners, individual commissioners can send direct comments to Christian or to I, or edits or suggestions are built into it. We just can't circulate those comments in that fashion, because then that's where we start, so if you have individual comments or edits that, you can submit that to us. It's just that, we start approaching that line on whether or not we can circulate the suggested edits that you have forward, that you want to have incorporated.
Thank you.
And unless others have a different opinion, I would propose to start the revision based off of the red line draft that I circulated this morning, which reflected Commissioner Bershauer's most recent revisions. That's the document I would propose to start with in terms of trying to exercise some version control.
Thank you. Version control. I like that. Well, let's get the Sherman County, let's get that version completely, just get rid of it, because it's just confusing things. And let's just go with Christian's red line version and then use that as our jumping off point. So do we have consensus, everybody? Okay, thank you all. Brad, thank you very much. I know you're under the gun. Sorry, probably not a good term to use. We know you're up against the clock. So thank you for the good work that you do over there. Best of luck to you today.
Thank you.
Sheriff, I know yesterday was a bit of a drama around here because we had an incident out by the courthouse. So I know that you're always looking for what the next issue is going to be. So thank you for joining us. We appreciate it.
Yep, not a problem. And if you guys, just for a point of clarification for next week, if you're wanting me to be involved, I will be teaching at the new Sheriff's Institute. So I'll be out all next week, but I could make myself available by phone if needed, or if not, I can just communicate directly with Christian and Ken on any concerns or no concerns if I have any.
All right. Thank you both for joining us. We appreciate it.
Thank you.
Bye.
Thank
So
you.
at this time, we'll move on to item H2, which is consideration of adopting a board order formally stating Yamhill County's opt-in, opt-out decision regarding the City of Newburgh's vertical housing development zone. This again was continued from February 21st, and we were waiting for some information from a number of taxing districts, including CPRD, and I'm wondering if we have any information. Oh, Derek is there. Thank you. He's our information guy. Derek, okay. Ken, yes.
Thank you, Chair. So I also, we extended an invitation, and Keith and Patrick are also available if there's specific questions that came up. And I just wanted to quickly remind that we're at that deadline. Today's the last session that we have to make a decision. And I was forwarding to all the commissioners. Keith was sending me updates as some of the other districts. The latest one that I don't believe I had an opportunity to forward yesterday was Soil and Water Conservation District did opt in as well. So far, you have Newburgh School District. I won't list them because I don't have it right in front of me, and I don't want to miss someone, but so far, all the responses we've received to date have opted in.
Thank you very much. Derek, our assessor and tax collector, thank you for joining us. So at this point, we have information from all of the taxing districts. Is that correct?
That question to me, Chair Sterrett?
Yes.
Okay. To Ken's point, I was CC'd on some of the emails that folks were opting in. I had not seen that anyone has opted out. And I think the remaining taxing districts are ones that you are either this jurisdictional body or ones that you're indirectly associated with, the soil and water or whoever else it is.
Thank you. Mr. Leonard, thank you for joining us. And Patrick is here as well. Thank you for joining us. So do we have a listing of all of the jurisdictions, and do we have a decision from all of them?
I can answer that. So there is one still out there, but it's my understanding they usually side with the school district, and that would be Willamette ESD.
So we have Willamette ESD, but everybody else has decided to opt in. Is that correct? Okay,
Yes.
Thank you. Christian?
Except for our extension service district.
Our
Yeah,
extension service, and we are going to be addressing that as soon as this meeting is over. So I don't know what the consensus of the board is, but we can go ahead and perhaps maybe discuss that as we make our decision here. Derek, is there anything else that you want us to consider as we make that determination as to whether we're in or out?
I think you've got it. I think we've covered it in the last couple of meetings. Good to see the follow-up from the other districts to get a feel and the appetite. Do we have a effective date on this? Maybe this is for Keith or the other gentleman that left. When will this zone go into place?
So the way we're doing this, we're going to bring it before the Planning Commission next month. Then I believe it's going to be May. Yeah, I think it's May before the first reading goes before the council.
Okay.
So there's some time, but it's just this ORS established 30-day response.
Yeah. So for us, board, it really won't be an administrative task until 2022. Too late in the year for 21 tax bill or any sort of exemption for that. It wouldn't be until 2022 that projects would be eligible, I'm assuming. And then from there, we'll see what happens.
Thank you. Commissioner Kula?
Thank you, Chair. I just wanted to note that Richard Riggs from OSU Extension is in the audience, and he has raised his hand. So I'm guessing he might want to join us if we're going to have the OSU Extension discussion.
We're not having that discussion until after the meeting, but I don't know, Ken or Christian, procedurally, whether or not we want to have input at this point or wait till the...
I was wondering the same thing. I know we had scheduled the ESD meeting for 11. I guess it would be possible if the board wanted to recess the formal session and go into the ESC meeting and make that decision immediately after this conversation and then come back. I know we have a land use hearing coming up as well. I didn't know if we wanted to wait for ESD until after the land use hearing. I see lots of hands from Ken and Casey.
I do see lots of hands. Ken, go ahead.
Well, I was just going to comment. I mean, if if he wanted to join the discussion now and just provide comment, I don't think that necessarily it wouldn't be any different than if you got an email from him before the meeting, before we convene, you know. So if he wanted to join and provide some input in this forum, I think we'd be fine. And then again, the decision can't be made for the extension service until we convene the board of directors, but you could have a discussion and get his input at this point.
All right, that makes sense. Thank you for that. All right. So Carrie, are you able to, where are we here? There's Richard Riggs. Okay. Thank you for joining us, Richard. Appreciate that. And thank you very much. So did you want to go ahead before our actual discussion after this meeting and just make some comment?
Yeah, Commissioner, sure. Thank you for the opportunity. I just want to say that the Extension Service District has no problem with opting into this, and that I'll just leave my comments at that.
Okay, thank you very much. Appreciate that. Commissioner Bershow.
Thank you, Chair. This is probably for Keith or Patrick, but I just have a point of clarification, which I've been asked this question and I hesitate to answer it because I don't know for sure, but does this district, will it start at a specific time and expire at a specific time, or is it project specific? So somebody could start to build something in 5 years and then you start the timeline of 10 years of the abatement.
Yes, it is project specific, but it is limited to 10 years. There's no extension beyond that for the individual projects. And there's about 4.71 acres of developable land within this area, and not all that 4.71 acres is prime. There are some that are smaller and probably won't work.
Okay, thank you.
Good to know. Thank you. So are we ready for a motion at this point? Does somebody want to make a motion on item H2, which is the consideration of the board order?
Chair, I'd be happy to. I just want to make sure I get it pulled up. Chair, I would move that we adopt a board order formally stating Yamhill County is opting in regarding the City of Newburgh's vertical housing development zone.
Thank you, Commissioner. Is there further discussion? Commissioner Bershower.
Chair, as I've stated before in past meetings, I'm inclined to support this, but I do want to make the continued point that these things affect taxing districts on a layered level. If you look at the bigger picture, that's when you start to really see the impact to certain taxing districts. And so going forward, I'm going to express concern about additional urban renewal districts and things that take money away from Newburgh schools or fire or whatever it might be. And I also have continued concern about how much of a benefit this is going to be for development, because the SDC fees are so outrageous at this point that I think they continue to be a barrier for growth and development.
Thank you, Commissioner. And I think I've been very clear also throughout the years about SDC fees. And when we compare, for instance, Newburgh and McMinnville, when we compare some of the SDC fees, the layered on, like the Parks District in Newburgh and the SDC fees in Newburgh, it makes it really difficult for developers to come in here. We've watched people walk away from potential projects for multifamily housing in Newburgh because it was just prohibitive. So I echo the same concerns that if we're talking about affordable housing, it needs to start with us. It needs to start with government and everybody who has the authority to tax, because the ability to tax can in many ways be the ability to destroy the incentive of the free market. So I agree with that, but we do have a motion on the table, and I will call for the question. All those in favor of item H2 in consideration of that board order signify by saying aye.
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 Aye. Motion passes. Thank you very much, Keith, for joining us, and for our assessor, Derek Wharf. And Patrick, thank you for joining us. We appreciate that.
Thank you so much for your support, and yeah, I can't thank your staff enough for helping us out through this process. So have a good rest of your meeting and good day. Thank you.
Thank you. Thank you very much. Appreciate that. All right, on to item I, which is other business, which is the consideration of accepting the quote and authorizing JK Painting to complete the courthouse complex exterior paint project in the amount of $99,861. Christian?
Yeah, I may look to Ken for some additional input on this, but this is the facilities request. They went through a competitive quote process, I understand, and this is one of the projects they're hoping to accomplish going into the spring and summer. It's a sizable project, and this is approving the quote. This will be followed up in the next week or two with a contract between the county and the contractor to perform this work.
Okay, great. So Ken, that pretty much sums it up, and the contract will be forthcoming. What he said, right?
What he said.
What he said. Okay, so then we'll put you on the spot next week when we actually have a contract. Thank you, Christian. On to item I2, the discussion of the Yamhill County Cultural Asset Award nomination. Commissioner Kula.
And it looks like Ken has a comment on this one.
Oh, no, Chair, the board didn't take action on the last item.
That's right. Okay, so do we have a motion to accept the quote and authorize the courthouse complex exterior paint project?
Chair, I move that we approve that particular item, and I'm pulling up the number to get the correct one.
$99,861.
All right, I move that we approve item I1.
Thank you. We have a motion. Any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. Motion passes. Okay, now on to item I2, which is the Cultural Asset Award nomination. Commissioner Kula.
And thank you, Chair. This email came to me, and I didn't know what to do with it, so I asked Ken, is this something that we all decide together on our nominations for that? We have not, as far as I understand, the board hasn't been involved in nominations while I've been on the board, but it's me bringing this up on behalf of a community member. So the nomination is for significant contributions to the cultural life of our community. It's the Marilyn Works Award is what I believe it's entitled, and it happens, let me pull this up. And it is every 2 years. And so with that, I would open it up that I'm not sure about the process that, Chair, you might want to follow, but it seems like a worthwhile endeavor. And it's also one that realistically, we probably could all submit nominations on our own if that was easier.
I remember being involved in a similar process a number of years ago and actually having some discussion with a group of people who were just looking at all of the various contributions of some people in our community. So there was that. I don't know, is that something that would be a resolution that we do? I don't know that I don't know that it sits with us.
Right, I know. I think that the request is that we submit a nomination, and that will be considered as part of the nominations of everyone. But it looks like Commissioner Bershauer has some thoughts as well.
Thank you, Commissioner. Commissioner Bershauer.
Thank you, Chair. You said it happens every 2 years. Who granted it last year? I guess I missed that part.
Commissioner Kula? Go ahead.
I'm looking at it. I don't think that I can't. Forgive me that I can't recall. But maybe Commissioner Sterrett can remember.
So I guess what I'm saying is I don't know that this is the correct jurisdiction for that. I would be happy to, for instance, when a decision's been made and there's been a selection made, that we acknowledge that or do a resolution to acknowledge that particular person, because they do go through a whole lot of vetting of getting lots of people's contributions acknowledged. I just don't know that it's us. Ken?
In taking a look at the request and the nomination, what I believe the request is, it was essentially an offer if the board wanted to consider nominating someone for this award or this recognition, then, and that's what the discussion is whether or not if the if the board would like to prepare and submit a nomination, and that would be if it's up to the board to discuss. And I think that's what the request is. And it was an invitation for Yamhill County Board of Commissioners to submit a nomination if they chose to.
Thank you. Commissioner Kula, your thoughts?
Yes, and in thinking about it more, since it is a request of the Board of Commissioners as part of a larger community nomination process, I'm happy to just submit a couple of names of people that I know in the community who I've seen in the past 2 years have made significant contributions, and that would be just exclusively then from me.
Okay, thank you. I just feel it almost limits, by us coming together with suggestions and nominations, we're cutting out, there's so many people to be considered. How do you say you don't make the cut? I don't know that it's up to us to do. I wouldn't feel comfortable doing it, because right now I could think of 5 people that I would say need to be on that list or need to be nominated. So how do we pick one? I would
exactly.
I'd have a problem with doing it as a board.
That sounds great. It was the person sent it to me, and I did my primary diligence by bringing it to the Board of Commissioners. I don't have a particular I don't feel a particularly strong need for a majority of the Board of Commissioners to submit a name or names, but because it was requested of me too, I'm happy to submit my own name.
Certainly, I appreciate that, Commissioner. Commissioner Bershauer, does that sound fair?
Thank you, Chair. Yes, that sounds fair. And forgive my ignorance, but what's the parent organization that gathers all of these and makes the decision? I don't have the agenda packet in front of me.
Okay, Commissioner Kula, you got an email regarding this. Do you want to go ahead and give us a little backstory?
Oh yeah, and I apologize. I thought I forwarded this on to staff, but it may have just made it on as just an agenda item rather than as the full document. So I can just do a quick rundown of it. It really doesn't actually have a lot of information, but it's the Yamhill County Cultural Coalition. So they are really, and I think, Commissioner Bershauer, that when you were a budget committee member, that you sat in on a presentation of theirs when they were requesting funding for, I think, a staff position to do more outreach and communications. So it's the umbrella organization that works with the Oregon Cultural Coalition or the Oregon Cultural Trust to coordinate arts and culture community, right? For example, what they did this last year was when the emergency board of the legislature set aside funding for cultural organizations. The money went to the Oregon Cultural Trust, and then each essentially cultural coalition across the state submitted grant applications from their jurisdictions or from their areas. And then they were the ones who then provided the funding to it. So they're definitely a go-between between larger organizations and locals. So like the Wildwood Music Festival or the Yamhill Heritage Center.
Thank you for that. And again, the Cultural Coalition, last time I sat in on discussions to choose a person, that was just wasn't a board action. So it had never come before the board before. So that's where that came from, but it was never a formal board action. But I do appreciate that, Commissioner Kula. So, okay, so we'll just go ahead, and the consensus is that Commissioner Kula will submit some suggestions on his behalf. Okay, so on to item I3, which is the discussion of SEDCOR hosting a Yamhill County State of the County Address event in the future. I brought that to our attention because we had a request from Abishaw Stone to look into this as to whether or not we wanted to do something similar to what Marion County is doing. And they put together basically a traveling type of road show on this. Well, now it's virtual. But in the past, what we used to do is we used to have one commissioner who was the chair would speak to Kiwanis or Rotary or Newburgh City Club, for instance, and just give the state of the county address. We haven't done that of late. But we also used to go around to various city council meetings and be able to just give an update on what's going on in the county. And we haven't done that as well as a result of restrictions on meetings. So I would just say that what my recommendation would be is, instead of a sort of a full-on presentation that we do separate from a board meeting, is that what we do is give an overall report, where that would include the county administrator giving us perhaps a budget outlook, or commissioners giving an update on their areas of liaison, and then the chair just sort of an overall opening statement, just so that we get everybody in there to present this information at a board meeting, which is typically when we meet. So are there thoughts on that?
I think that makes essentially that would be the same thing, but maybe with less complex as what the Marion County Board of Commissioners does. So I think that's reasonable, Chair.
Does anybody have any thoughts on when they think this would be everything seems to be so busy these days, and asking staff to do something else. I don't feel comfortable giving Ken another, here's something in your pile of stuff to do on your desk. But is there perhaps, do we want to maybe after budget be able to do, after we've come up with the budget in June and we've adopted the budget, to give an outlook on what the budget looks like and an area of liaison update? That makes sense?
I wanted to make sure Commissioner Bershauer had an opportunity.
Thank you. Commissioner Bershauer?
I wasn't sure, Chair, if you were looking at Ken for approval. He's not nodding his head, so.
I'm always looking to Ken for approval, but that doesn't usually happen, so we'll just move on. Commissioner Bershauer.
I like the idea. I was talking with Ken this week about how it seems like the budget memo that comes out with the budget, that one pager that kind of precludes
the tabloid.
It does a good job of describing, kind of where we're at in terms of funding and revenue and expenses and stuff like that. But I would agree that we don't really have a way of communicating holistically, what the different departments are up to, the positive things that are happening, that kind of stuff. So I would be open to it. I have found that almost every meeting so far, we never get to announcements because we're so busy with other things. So I guess I would hope or expect that if we do it sort of is the agenda of the meeting, so that we're not piling it on to something else.
Thank you. I appreciate that. And I know that these meetings, some of the meetings we've had lately have involved a lot of long discussion items. So I think that would be ideal. There's so many announcements we don't get to. Ken?
All right. I think we could schedule something. Admittedly, the one part that because I know we talked a lot about the budget process, and I'm trying to think on how this interfaces with what we have under Oregon budget law, with all the various steps that we have that go with that. It kind of seems that if this is intended to be more of an informational and kind of the status, I would probably recommend doing something, especially if we really wanted to talk about budget, that it might be post-budget adoption, to kind of talk about, because we already have several. We have 3 days of budget committee meetings, and then we have 2 hearings that occur during that process, and then we get to the budget adoption in June. And I do realize that the budget is a priorities, an establishment of priorities, and it demonstrates and documents where those priorities on how we determine what we're going to spend money on for the next year. And so I could see that kind of dovetailing into kind of a post-adoption, budget adoption type format that, you could give updates from areas of liaison, and we can go more in depth on some of the operational plans or concerns, or, kind of going through that SWOT, that strengths, weaknesses, opportunities, and threats kind of discussion presentation. So, my recommendation would be to kind of target for something, post adoption. And I also just know workload, as you know, when we're working on budgets, this is a very busy time of year, getting the budget put together. So that would just be my thoughts and recommendation on timing for something like this.
All right, so why don't we go ahead and tentatively plan on a state of the county for a week after budget adoption, and that is usually the first week in June. Is the budget adoption?
July. The budget adoption is usually the last formal session before the end of the fiscal year, which
Okay.
is June 30.
Okay, so we're looking at the beginning of perhaps the beginning of July to plan a state of the county address, which I think makes the most sense. So we'll have some time to look at that and maybe have a better idea. Okay, thank you very much.
And Chair, I think we might have a better sense of what our post-pandemic world will look like. And that might be a really good time to kind of go over everything that has happened and what departments are doing moving forward.
Great idea. Thank you very much.
Yeah.
Yes, Ken.
And I would just add to that, it would also help dictate what the format of this session is also going to look like. If it's part of a formal, if it's something that is being presented, is it a Zoom meeting? Are we meeting in person? A lot of questions around that, around the format.
Thank you very much. So we'll go ahead and we'll plan that for after budget adoption. Now, I have a question. Would we be able to, since we did notice that the Extension Service District Board of Directors meeting was for 11, would we be able to do that now and then do our public hearing?
I think the difficulties we have is because we keep those minutes separate, and there's some technological challenges as far as recessing this, and then we're unable to separate that record. We're unable to splice and separate and do that. So unfortunately, I think because of the technology limitations, it'd probably be better to go into the hearing, and then as soon as, post-hearing, then reopen as the extension service. So that way it's a separate minutes and recording.
Makes sense. Okay. So I'm going to ask if there's consensus for us to take a 5-minute break before we go into the public hearing. Is that something that we would all agree to? Okay, so let's go ahead. It's 11:47. I thank everybody who is standing by for the public hearing. We'll just take a 5-minute break and then come back. Thank you all. All right, it looks like our planning director is joining us from San Francisco. How lovely to see you, Director Friday.
This doesn't inspire confidence in us.
He looks like he's about to fall off a cliff. Desiree, nice to see you, and Todd Sadlow, always a pleasure. Thank you, everybody, for coming back. At this point, we will open up the public hearing, and docket C 22-20/SDR-26-20, which is an application for conditional use and site design review for a wine production facility, winery, and by appointment tasting room, tax lot number 3321-913 10275 Northeast Warden Hill Road, Dundee. The applicant is Jared Etzel. The owner is Etzel and Lubunsky LLC, and the appellant is Elizabeth Seeberger. At this time, Commissioner Ken, did we need to close the informal?
No, you're fine. The hearing's open. I just wanted to just quickly go on record and just as part of the hearing and just make a note. This is our first land use hearing that we are doing in this format. And so I just wanted to acknowledge the fact that this is the first time that the Board of Commissioners is conducting a land use hearing via Zoom in this virtual format. And I just want to ask for patience as we navigate this process because, again, there's a lot of things happening that's new behind the scenes that staff is having to navigate with conducting this hearing. And I just wanted to put out an apology if mistakes happen or things, but we're trying our best to make sure that we can continue with this land use hearing in this format, but we're learning as we go. And so I just wanted to quickly just make that statement for the record. Thank you, Chair.
Thank you. And I also want to say special thank you to Carrie Hinton for her patience and for Carolina for navigating through this. It's been pretty complex. And I also want to thank our folks in IT for jumping in, John and all the folks who were jumping in this morning to try to make this happen. So at this time, I'll call for abstentions from members of the board. Any members of the board need to abstain from this case? Seeing none. Are there any parties here to this case that are objecting to the jurisdiction of the board?
No, but Chair, I just wanted to go back. Are you on ex parte contact or not?
No, I'm not there yet.
Okay, that's good. I just wanted to make sure,
All right, so we have no objections to the jurisdiction of the board. Item number 4, does any board member need to announce a substance of any ex parte contact or any site visits? Commissioner Kula?
Thank you, Chair. No site visits. Elizabeth Seeberger and I in the past have spoken about issues on this particular stretch of road. So I just wanted to note that I haven't seen anything in the record that is other than what we've discussed in the distant past. So it's all on the record.
Thank you very much. Thank you. Oregon law requires that persons who attend a land use hearing be advised of certain rights and duties before the hearing. And that is where we'll bring Todd Sadlow in.
First, with regard to the standards of approval, state law, ORS 197-7635, and can you hear me just fine? All right. Requires that we list the applicable substantive criteria that must be met in order for the county to approve the application. The standards will be listed by Desiree in a moment as part of the staff report. Testimony, arguments, and evidence must be directed toward the standards for approval. Second, the raise it or waive it rule. Under Oregon law, any issue that might be raised in an appeal of the county's decision in this matter must be raised before the record of this hearing is closed. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision makers and the parties an opportunity to respond to the issue precludes appeal to the board based on that issue. Third, and this is directed to the applicant, under ORS 197-796, failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval, again, with sufficient specificity to allow the county to respond to the issue, precludes an action for damages in circuit court. This is not the initial hearing, so there are no automatic rights to any continuances in this matter. Madam Chair.
Thank you, Todd. Thank you, Todd. I appreciate that. So we'll go to our staff report. Desiree?
Good morning, Chair, Commissioners. I see Administrator Heffer's raising his hand.
I just quickly, before we got into the staff report, I've noticed that Catherine Jernstead has raised her hand, but I don't know if it's appropriate at this time. Todd?
What I would say is that we know that there's an issue with the request for de novo hearing and an objection to a de novo hearing, which I don't think we've ever received. And so what I would like, or I would think would be appropriate, is for Ms. Lundin to give the staff report, and then we have a discussion of the de novo and allow the parties to comment on just the de novo before we go into the applicant's case. And the applicant and whoever wants to is going to speak on behalf of the applicant and go on from there.
Thank you. Desiree?
Good morning, Chair, Commissioners. The applicant's parcel is approximately 9.4 acres in size. The assessor's office records indicate that the property has 7 acres receiving farm tax deferral. The property is located within the exclusive farm use EF20 zone. The property is currently planted with approximately 7 acres of Pinot Noir and Chardonnay vineyard. The property does not currently have any structures, and there is an existing on-site well. The property underwent a lot line adjustment to receive its current configuration through docket L1907. A replacement dwelling inspection was completed and is valid through August 15th of 2021. The parcel has direct access to Northeast Warden Hill Road by way of an existing driveway located near the northern boundary of the parcel. The application indicates that if approved, the use would be served by a circular drive beginning with ingress at the existing drive and egress along the southern boundary of the parcel. Properties to the north and east are zoned exclusive farm use, EF20 and EF40. These parcels are a mix of agricultural and rural residential uses. The agricultural uses are dominated by vineyard, but also include grass and hay production, Christmas trees, and livestock pasturage. There are also a number of wineries and tasting rooms throughout the surrounding area. To the west and south, the surrounding properties are zoned forestry large holding F80. The uses in this zone are commercial and passive forest uses with some rural residential uses throughout. The applicant's request is for conditional use and site design review for a wine production facility, a winery, and by appointment tasting room. The request needs to be shown to be consistent with sections 40204 subsection G, 40207 subsection A, 110102 and 120202 of the Yamhill County Zoning Ordinance. Comprehensive plan policies may also be applicable. This application was deemed complete on November 3rd, 2020. A request for hearing before the Planning Commission was received during the 15-day comment period on November 20th of 2020, and a hearing was held on January 7th of 2021. The appellant requested that the record be left open for additional written evidence and testimony. The commission left the record open for 1 week for additional evidence, a second week for rebuttal, and then a week for applicant's final rebuttal. The hearing was reconvened at the February 4th, 2021 Planning Commission hearing, where the Planning Commission passed a motion of approval 6-0 in favor. The request for appeal was received on February 19th, 2021. The first item to be decided in this application will be whether to hold the hearing de novo or on the record. The request for appeal received by appellant Elizabeth Seeberger requests that the hearing for this matter be heard de novo pursuant to section 140304 of the Yamhill County Zoning Ordinance. The applicant, through his attorney David Peterson, has objected to this request and to having the record reopened on this matter. In the alternative, applicant's counsel has requested that the board hear the appeal on the existing record. Correspondence from applicant's counsel was received by staff on March 2nd, 2021, and was provided to the board via email on March 3rd, 2021. An email received by staff from the applicant on March 4th, the appellant on March 4th, 2021 was provided to the board via email the same day. Staff notes that historically, land use matters brought before the board have been conducted de novo. Senior Assistant County Counsel Todd Sadlow may have additional information to share regarding this should the board have questions. Should the board decide to hear this matter de novo, staff will need to email the commissioners additional testimony that has been received after the close of the open record period and prior to the close of today's hearing. Lastly, the county has 150 days from the date that the application was deemed complete to render a decision on land use matters such as this. That includes any request for hearing and/or request for appeal with the Board of Commissioners. This application was deemed complete on November 3rd, 2020. By staff's calculation, the 150-day period will end on April 2nd, 2021, and the applicant's counsel has stated that they do not intend to waive the 150-day period. Whether the application is on the record or de novo, we would encourage the board to deliberate and vote no later than next week, March 18th, to allow 2 weeks for findings to be drafted and adopted prior to April 2nd, 2021. That concludes my staff report.
Thank you very much. And Todd, at this point, is it appropriate for the board to decide whether or not this will be heard de novo or on the record?
Yes, I would point out that the section says that the board may, at its option, whether or not upon a motion of a party, hold a de novo hearing or admit additional testimony. And you are told that you shall consider prejudice to the parties, convenience of locating the evidence at the time of the initial hearing, surprise to opposing parties, when notice was given to other parties as to the attempt to admit, and the competency, relevancy, and materiality of the proposed testimony and other evidence. And I would just say that we have always, to my knowledge, the county has always, at least going back as far as 1986, conducted a de novo review by the board and admitted new evidence while also considering all of the evidence and testimony that was submitted before the Planning Commission. If the case is appealed to LUBA, everything that's already in the record will be part of that record on review, as well as if you allow testimony and evidence to be submitted at this hearing or in advance of this hearing, all of that testimony and evidence would also be considered. So in terms of prejudice, I guess it would be best, and these other factors, I think it would be best to allow Ms. Seeberger to address her motion and then to have the applicant have an opportunity to reply to that. And then you make a decision whether or not to have your consideration on the record of the Planning Commission or to allow additional testimony and evidence today.
Thank you, Todd. Appreciate that. So let's go to Ms. Seeberger, if you are available.
If we can get her.
And we'll go ahead.
Where the rubber hits the road, huh?
And Chair, I was just wondering, since Catherine Jernstedt had her hand raised, perhaps she intends to be part of that argument for de novo. I'm just wondering if that's the case.
Right. Let's go to Elizabeth Seeberger and have a comment regarding the de novo issue. Ms. Seeberger, thank you for joining us.
Thank you.
Go ahead.
So,
Go ahead.
So I'm addressing the issue of bringing in evidence, and I'm going to have my husband help me here.
Good afternoon, Chair and Commissioners. My name is Jerry Seeberger. Elizabeth's my wife, obviously. And just to this specific issue of the de novo hearing, as Todd Sadlow has indicated, traditionally in Yamhill County and in the past, we've had two other issues that we've dealt with. One, a cell phone tower about 10 years ago, more recently the St. Michelle matter. Both of those were de novo hearings, and that's been our experience previously with this and other issues and other people that we've talked to. That's always been the position the board has taken and allowed to rely on the initial evidence of the Planning Commission as well as the additional evidence that would be given today. In terms of prejudice, I think my wife submitted a letter in response to the submission by counsel for the applicant that indicated why he believed a de novo hearing should not be allowed. And she addressed the timeliness of that we had to deal with this issue. It was only a few weeks. Christmas was involved. Of course, with COVID, it made it difficult for the original submissions. And since that time, what's telling is that we did address some of the issues that the initial traffic study that was done by the county and raised issues that we felt were inappropriate. And to the county's credit, they did a new study as indicated in counsel's letter, and he wanted to limit it to just that alone. I think that in itself indicates that we don't know what the commissioners, when they made their decision, to what extent it played into their decision, that traffic study. And to only have that portion open and not allow other evidence it just makes probably an appealable error right in and of itself. The reasons my wife has stated previously for the new information that I think would be helpful to council to make their decision today, we'd ask that the hearing be held de novo as traditionally has been done in this county. Thank you for listening.
Thank you very much. Appreciate that. Ms. Jernstad, are you there? Are you available to comment on the de novo? Ms. Jernstad?
I think she's heading in.
Have I succeeded in unmuting myself?
Go ahead, we can hear you.
Thank you. I would also like to reinforce the importance of a de novo hearing. As Mr. Huffer stated, these Zoom meetings are a learning process. And specifically when the Planning Commission deliberated on this issue, we were not able to do anything more than watch it, and some of us were not even able to do that. There was a question about material that we had submitted in the open record period by Commissioner Halstead, who was unable to get recognized by the chair. And he did vote for it, but because of the limitations of some of these processes, we feel that it's important that now that we've learned some more and we're doing a little better with Zoom, that we go ahead and do this as a de novo hearing.
Thank you very much. Do we have anybody else who wants to weigh in? Does the applicant want to weigh in on the aspect of a de novo hearing?
Chair, I think we've got one coming on.
Mr. Etzel? Mr. Etzel, are you unmuted? Here we go. Mr. Etzel, if you want to unmute, then we can go ahead and hear your, here we go.
Yes. Hi, Jared Etzel here. My wife, Erica Etzel, and David Peterson, who's helping us through this process. I'll let David kick off relating to the de novo.
Yes, go ahead.
Yes, good afternoon, members of the board. My name is David Peterson. I'm an attorney with Tonkin Thorpe, Portland, Oregon. My address is 888 Southwest 5th Avenue, Portland, 97204. With respect to the de novo issue, I'll be brief because you do have my letter, but your county code, I think, is fairly clear on this point that these kinds of hearings will be held on the record unless there's a specific justification for conducting a de novo hearing. And the 5 factors are listed in one of your code provisions that Mr. Sadlow read out. And quite frankly, there's really hasn't been any suggestion that any of those factors are present in this case. To some degree, I'm going to be bleeding over into my substantive position on one of the grounds for appeal, which is the questions about procedure. So if you'll bear with me about this, and I won't bother repeating myself later when this comes up again. But to review very briefly the calendar here, this matter was scheduled for hearing on January 7th, 2021, before the Planning Commission. The staff report was made available on December 22nd, which was 16 days in advance. That's more than twice as much time as is required by statute. Statute requires the planning report, the staff report, to be out 7 days in advance. There was a hearing at which all parties had an opportunity to participate. There was an additional record period of 7 days, which is what the statute requires as well, and is very common in land use hearings when the record has been requested to be held open. Followed by another 7 days, again, very common and statutorily required period for rebuttal, during which evidence could still be submitted in rebuttal to things submitted during the first open record period. So all in all, the opponents on this matter had from December 22nd, 2020, when the staff report came out, until January 21st, which is just about a full month, to submit all evidence and argument that they chose. And there's been no reason to think that the Planning Commission was somehow hindered or restricted in considering that evidence and argument. And quite simply, there's really no justification under the county code for holding a de novo hearing. I understand from what I just heard earlier that you have a long-standing tradition in this county, and I realize maybe I'm swimming upriver against a standing tradition, and that's okay if that's the decision the commission reaches. I will say, however, though, that if this is going to be a de novo hearing and some new evidence is going to be submitted, then there's going to have to be an opportunity for parties to rebut, or we're going to be in trouble should this matter go to LUBA. And you are up against a relatively short time window. So if you do ultimately decide to go de novo, I would ask that your any continuances to allow parties to rebut be sufficiently short to make sure that we can get a decision done by the 2nd of April.
Yes, duly noted. Thank you.
Thank you.
All righty. Do we have anybody else who wants to weigh in on the de novo aspect of this? So Todd, at this point, we're going to take is it an actual formal vote, or is it consensus of the board on how we move forward on the de novo aspect?
I think you should accept I think it'd be cleanest if you accepted a motion and either decided to have the de novo hearing or to not have it. And based on your decision, we will adopt findings when you make your final decision in support of whatever decision you make.
Thank you. Do I have a motion from the board to move forward with a de novo hearing or to accept the case on the record? Commissioner Kula?
Thank you, Chair. After listening to both the appellant and the applicant, I think it's reasonable to move forward with a de novo hearing. I think that too much doubt has been placed on whether folks have been able to put all the evidence in the record. I know that there's this question of the public works and their traffic study, or I don't think that's the real word for it, but their traffic counts. I just want to make sure that we do here, acknowledging that this is this is our first major land use hearing in the virtual world.
Thank you. We have a motion.
Sorry, that was a motion plus discussion. Apologies, Chair.
All right, we have a motion to move forward in de novo for de novo hearing. Is there any further discussion? Commissioner Berschauer?
Thank you, Chair. I'm inclined to support the de novo hearing, but I want to make sure now that it's March 11th and we're running up against, what was it, April 2nd was the deadline. That's a pretty quick turnaround. So I want to make sure that if we are going to provide additional time for input, that we are also respecting the applicant's timeline.
Thank you for that. And Todd, that would give us to leave the record open if we were to vote on this till Tuesday, and then to allow for the adoption of findings and deliberations and a vote.
Madam Chair, if there is new evidence being submitted, and it looks like there probably is, there needs to be some opportunity for rebuttal. And I think that it's reasonable, and we've had periods like what you're saying there to next Tuesday, the 16th at 5 p.m. for written rebuttal to any new evidence that either has been placed into the record since the Planning Commission hearing or is placed into the record today.
So we would have sufficient time if we were to move forward in de novo. So we have
I
a
believe you
motion.
would.
Thank you. We have a motion to move forward for a de novo hearing. Any further discussion? Hearing none. Commissioner
Chair,
Kula.
sorry, I just want to make sure my motion did not include a timeline, but let's make sure that we have a timeline when we're before we're done today. Councilor Sadler, would that be a correct way of doing it? Is motion now and then decide on a timeline? Okay, great. Thank you, Chair.
So we have a motion. We have a motion to move forward with a de novo hearing. If there's no further discussion, all those in favor signify by saying aye.
Aye.
Aye. The motion passes. So we will move forward, and this will be a de novo hearing. Thank you, everybody who weighed in on that. We'll move ahead to the applicant's case, and we will start with the applicant. So if I could ask that you state your name and who you are in this hearing, it will give us an idea of who we have when we reflect this in the minutes. So we'll start with the applicant, please.
Hey, yes, it's Jared Etzel.
Hold on a second, Joe. So wouldn't typically the appellant go first? I mean, we'll do it how you want, but that's what I would have expected.
No, sir.
No, we want you to go first and put on your case as if you were having a de novo hearing.
All right, so we're going to start with the applicant, and if we could have the applicant go first. Thank you.
Okay, perfect. And I have a question of point of clarification. So will I have a period to essentially state my evidence and argument after today's hearing, or do I have to put everything on right now?
Madam Chair, if I may comment, the board has not decided what to do with the time frame yet, but it sounds like there is a tentative period of until March 16th, or would be, for a response to any testimony and evidence that's put in the record today. So this tentatively anyway is the last opportunity for you to make your case, and all of the evidence and testimony you've already provided is in the record and has been provided to the board. So if you got anything else, this is the time to do it, and the time to get everybody's evidence and testimony on the record with just a limited rebuttal for next Tuesday that does not include new evidence.
Okay.
Thank you, Todd.
Okay.
Go ahead, Mr. Etzel.
Yeah, thank you very much. I'm gonna pull up a file here that hang with me. Just one quick moment. One moment, I apologize. Okay. So I'm a well-respected member in the Warden Hill community, and our family has had a positive reputation for helping those around us. We'll continue this effort with the proposed winery and join more than the 10 equivalent size approved existing wine projects in Dundee. As seen from our letter of supporters, I have a strong support from the neighborhood on Warden Hill Road, including some of the most prominent and successful farmers and business people in Yamhill County. I have an enduring passion for this property and look forward to working with it to reach its best. I will follow the guidelines of the county and be a good neighbor. If the appellant continues to contest, I will respectfully appeal as far and as often as necessary until we reach a conclusion or approval. The appellant is, well, I'll move on to my next point. So my family's been involved in making wine for 35 years. We have an excellent reputation. We're not going to tarnish that reputation with this small by appointment winery. I think that the scale of the winery that we're proposing is very appropriate for the property and the area. The square footage of the total commercial space is only 1% of our total property. So it's quite small, and all the buildings are placed on the west end, far away from Warden Hill Road and far from the abutting neighbors. In regards to my request for the case quantity, an outright permitted use winery is allowed to make 21,000 cases of wine, and that's outright permitted if there is 15 acres of existing planting vineyard. I only have 7 acres planted. And so if you extrapolate the math and figure out based on 7 acres, so if you did 21,000 cases divided by 15 acres, that's 1,400 cases per acre. If you take the 1,400 cases times my 7 acres planted, that's 9,800 cases would be a logical request for my permit based on the permitted use, but I'm only requesting half of that roughly at 5,000 cases. So it's a very, very small winery, and this is the minimal amount that we need in order to make it financially a viable system. There are many existing approved wineries and tasting rooms in Dundee with the same or smaller total property size than my property. And that includes Firesteed, which is a 4-acre property with 0 acres of vineyard. Furioso is approximately 9.6 acre property and an 8-acre vineyard. Cremoise, 10-acre property and a 6.5 acre vineyard. Cameron Winery, approximately 12-acre property with 7-acre vineyard. Dusky Goose, 10-acre property with 8.4 acre vineyard. Barrel Fence, 10-acre property and 8-acre vineyard. White Walnut Winery, 7-acre property and 6.4 acre vineyard. The Dundee Wine Library, 10-acre property and 1.1 acre vineyard. And to my knowledge, none of these projects have had reported issues due to their scale. So there's, and this is just in the immediate area, surrounding Warden Hill Road. If you look in larger Dundee area and broader in the Willamette Valley, there's even more wineries on the same scale as mine that have worked, operated, followed all the conditional uses and have a precedent of approval. We're planning to invest quite a bit into these facilities. Roughly $3 million will be spent on the construction, which will go directly to local small building contractors and help the local economy during a challenging economic period, as well as, it's a small winery, so there won't be a huge number of employees brought on board, but there will be some employees and, obviously tax revenue generated in that sense. Warden Hill Road is a significant public road connecting Highway 99 and Highway 240. And my proposed microscopically sized winery is not going to significantly alter the traffic on this road, as seen by the initial traffic study. Additionally, the county road study, well, yeah, I just said that. They found no evidence of inadequacy, including sight lines. My sight lines to both of the driveways exceeded the requirement. And another argument on this is my winery, because this is on Warden Hill Road and it's very small and mine is by appointment or would be by appointment if approved, is not going to draw a significant amount of new traffic. It'll predominantly be from people that are already on the road visiting the 10 plus other wineries that will be visiting my place. So I don't think one could argue that my project is going to alter the traffic issue. Let me see here, what else arguments I would like to place. I just have, my letter of support with 12 signers, just to show that essentially it's not me against the world on this. Mrs. Seeberger has raised a number of contestants, or supporters on her side of the argument. And Mrs. Seeberger, please correct when it's your turn. But I believe that only 3 of the 4 people that are signed supporters on her side of the argument are on Warden Hill Road. The remainder 10 plus are on Fairview Road, which is a connector road off of Warden Hill, which is not significantly impacted by the traffic on Warden Hill Road, because Fairview Road, it loops around and there's a large portion of it that's still gravel. And so the wine tourism route on Warden Hill into accessing my project, there would be close to 0 impact on Fairview, which not all, but most of her supporters are residing on Fairview. Their second argument that they've been continually kind of bringing up is water use. And water use, obviously not under jurisdiction of county. It's a state jurisdiction item. But I want to add that my well is from 1974, and so I have existing and senior water rights to most people on the Hill, and outright exempt use of up to 5,000 gallons per day in support of an approved commercial process, and up to 15,000 gallons is exempt for a household use. I am taking every precaution that I possibly can in order to limit and minimize and save the water that we possibly can. We're putting holding tanks. We've agreed to even put a water meter on our well, which is above and beyond what is required. And I talked to Joel Fan, the water master of the state, and he said to me, they have very little case on this. You have a permitted use with your well, and you're following all the guidelines. As long as you're sticking to under this 5,000 gallon per day issue, there's not much that can be done. My docket now has been open for approximately 128 days of review period, which in my opinion is allowed really considerable amount of time by all parties. There's been one traffic study that's been made public. The next one, it sounds like will come into play and will be presented, but it follows the same conclusion that the previous study had, in the sense that it finds that there's no evidence that my project would increase the traffic significantly, and the sight lines and everything are very much in line. To me, it feels a bit like the appellant is, requesting open docket, which is fine, and now requesting de novo. It seems a little bit like they're trying to just exhaust me to walk away from the project, which I'm not going to do. I love this vineyard and this project, and I've put everything that I have into this, and I'm following all the guidelines and rules, and I don't feel that it's right or correct. That concludes my portion, but I want to have allow David, my attorney, to weigh in here one last time really quickly. Thank you.
Thank you, Mr. Etzel. Yes, sir.
Will there be any opportunity for rebuttal after the appellant's presentation?
Yes.
Yes, okay. So I feel like Mr. Etzel did a fantastic job of representing himself, and I'm not entirely sure why I'm here, but that's just a joke, of course. I do want to touch briefly on the grounds for appeal that were stated in Ms. Seeberger's appeal statement without repeating the things that Mr. Etzel said. Her first ground for appeal was we were not afforded our full due process participation rights. I think that's been rendered moot by the fact that you're holding a due process, or you're holding a de novo hearing now. Her explanation on that grounds was essentially that they didn't get an adequate opportunity to be heard, and that's being rectified by the de novo hearing that you're holding. The second grounds, the development impacts the use of roads nearest the proposed use, and therefore threatens the safety of those traveling upon the roads, whether by foot, bicycle, or vehicle. This may change after we hear from the appellant, but at the moment, the most important consideration here is that the only evidence we have in the record about the traffic impacts of this project are the traffic evaluation by Mr. Hafner, the engineering county manager, that shows that the impacts on this road are minimal now, and the impacts from this project will be minimal thereafter. And as Mr. Etzel said, you know, it's hard to imagine that one more winery in this area is going to draw a whole bunch of new wine tourists to the area. What's going to happen is existing wine tourists are going to have one more place to stop. So, you know, the evidence in the record that you have now shows that traffic safety is not an issue for this proposal. I will reiterate that if something new is introduced after I've spoken, that we would like our opportunity to rebut. Thirdly, the potential future impact of the commercial use of water will affect the uses which require water within the vicinity. As Mr. Etzel explained, he has an exempt well that entitles him to 5,000 gallons per day. He's committed to not exceeding the 5,000 gallons per day limit, and his water right is a relatively senior one. So, you know, any sort of rationing of groundwater, should that happen, is the responsibility of the state and is not an issue for this permit. Lastly, Ms. Seeberger states that the proposed development changes the character of the parcel from domestic use to a commercial use, thereby bringing commercial activities to the residential neighborhood. The various impacts are both subjective and objective, nevertheless objectionable. So I think this statement of appeal mischaracterizes the facts in a number of ways. This site is not in a residential neighborhood, it's in an agricultural zone. The property is zoned EF20. Most of the opponent's home sites on Fairview, if not all of them, are also zoned EF20. Also, the proposed use does not abandon a domestic use. It merely expands an existing agricultural use, which is a vineyard, by adding an associated commercial activity as is expressly allowed as a conditional use in this zone. I do want to read to you a quote from your own zoning code. It's the purpose of the farm use districts, and it's in Yamhill County Zoning Ordinance Section 40201. It says, in exclusive farm use districts, non-farm residential and other development, which might likely be affected by normal farm management practices, will be limited or prohibited so as to maximize the productivity potential of vicinity farmlands. So if people are going to choose to live in an agricultural zone, they have to accept the impacts of the agricultural uses around them. And I'm sure that this board well understands that, being an agricultural county that has produced a lot of agricultural revenue and jobs for quite a long time. And so I think the appellant has stood this on its head and is trying to get the agricultural use to adopt the non-farm use, and that's not the way it works. The non-farm users need to accommodate the agricultural uses that are permitted in the zone. Lastly, I will point out that notwithstanding what I just said, Mr. Etzel has designed his project in a way to minimize impacts on the opponent's neighborhood. He's locating all the facilities on the far west side of his property, screened from Ms. Seeberger and other residences on Fairview by the existing vineyard. All of his uses will be at least 590 feet away. He's only going to accept visitors by appointment, which is going to allow him to spread those visitors out across the day and minimize the impacts of that use. So we believe that the record shows that none of the grounds for appeal have merit. We are confident that that will be the case even after any new evidence may be accepted. And we respectfully request that the board approve the Planning Commission and uphold this permit. I'm happy to answer any questions if you have them.
Thank you. Commissioners, any questions? Okay. Yes,
Right
go
now-
ahead, Commissioner Kula.
No, I just wanted to acknowledge, I'm gonna reserve my questions for the rebuttal time.
Okay, thank you. All right, let's move on to, thank you very much for that. Testimony in support of the application. And if we could have those who are going to make testimony in support, give us their name and their address and make it clear that you are in support of the application. And if you could keep your comments to keep them to a minimum. And also, if you've submitted application by testimony by written testimony, don't necessarily repeat that. And again, we'll go ahead and hopefully we can keep our comments brief. So we'll start out with those who are in support of the application. If you could give us your name and your address for the record. And if your name is unusual or an unusual spelling, if you could spell that for us. Ken. Ken, you're muted.
Muted. That's the first time that's all right. We just asked for those that are attending the meeting, and if you're wishing to make public comment, there's a raise your hand function. And so if you raise your hand, then it lets staff know that you want to be promoted to the panel and make your comment.
Thank you for that, Ken. So at this time, we're asking for people who are wanting to make testimony in support of the application to raise your hand now, and one by one, Carrie Hinton will let you into the queue and give us your name. So we'll start with those who've raised their hand in support of the application.
And Chair, I don't know if you can see it, but I'm looking at the attendees list and I'm not seeing any of the attendees. The 8 attendees that are shown in the panel, none of them are raising their hand at this point.
Okay, so then what we'll do is, so then Todd, are we then basically, if we don't have any in support of the application, moving on to the appellant's case?
The appellant's case, that's correct.
Thank you very much. So at this time, we'll move on to the appellant's case, and that would be Ms. Seeberger.
Thank you.
And if you could just once again state your name so that we have that on the record.
My name is Elizabeth Seeberger. I've lived on Fairview Drive for 15 years, and I am going to keep my submission much more brief than what I have submitted into the record. I hope that you do have that available for you to look at, because the evidence I have would be important to look at it. So rather than reading much of what I wrote, I will, oh, and do you have the submissions with you?
Ms. Seeberger, we have all the submissions that the planning department has sent us. We have read it. I know I can speak for myself and my fellow commissioners. Is typically the case that all of it is read, and thank you for that. We have acknowledged that we've received.
Okay, thank you. So this neighborhood was formed in 1892, named Dundee Orchard Homes, also known as Orchard Homes Estates, and is still referred to that today as per the tax assessor records. It is a rare area in the midst of an exclusive farm use zone. Exhibit 1 is the one that has the map dating back to 1892 that divided this land up. Much of it remains the same as today, noting, of course, that it is residential. This cluster of residential parcels extends a mile east from Mr. Etzel's vineyard. Per the tax property description, his parcel is in the subdivision of Dundee Orchard Homes and is entitled number 2. His property has been used as a residence since 1974. In addressing the issue of the surrounding use, to the west of Mr. Etzel's property, 20 or more acres of farmland. To the south, 20 or more acres of abandoned equestrian facility. To the north, 30 acres or more of vineyard without a winery, without a tasting room. To the east is the Dundee Orchard Homes and extends the 1 mile. With this surrounding area, mixture of uses is about 40 parcels. I'm referring to the Dundee east of the property. The dominant use is residential. The farming and businesses on Fairview Drive, this surrounding area, does not involve any public participation. Both staff report and Mr. Etzel state the dominant use is vineyard. When referring to use and not acreage, the dominant use is clearly residential. Not one use of the surrounding area brings the public to its property. Because of this, there has not been any change in the already use of water availability, no increase in traffic noise, no increase in the dangers presented with increased traffic, no increase of the public who don't live here and don't care about throwing their coffee cups or other trash on our road. This application threatens the nature of this particular rare area. 30 years ago, not 10 years, as Mr. Etzel stated in the Planning Commission, those who lived here paved Warden Hill from essentially the Red Barn down through Crabtree Park and up towards Mr. Etzel's property itself, paved by the people who lived here. Regarding Fairview Drive, most of the people who still live here contributed up to $158,000 to pay for the asphalt on Fairview Drive. We paved it because of the dust directly caused by the increased traffic of wineries, which are accessed, that's true, by Fairview Drive about 2 miles away. Many of the neighbors here wished we had never paved the road because it paved the way for the public to come. We love this area and we have sacrificed for this area to maintain the quality of life here that we chose to take advantage of the residential Orchard Homes estates. The county has shown respect unintentionally for this unusual area in the EFU land by addressing the issue of urban development expanding into the rural area. The county recognizes that there are conflicts created when combining the two activities and states in the comprehensive plan that the major concerns connected with any rural area development proposal are its location, its nature, its scale. We appreciate the county recognizing this and asking you, the Board of Commissioners, to consider this application in the same recognition. We also commend the goal that is to provide an adequate amount of land, development areas, and sites to accommodate those uses which are customarily found in the rural areas and are better suited to rural location without compromising the basic goal relating to urban containment and orderly urban development. The action taken towards that goal is described within the policy. Policy A, agricultural, forestry, small holding designated lands encourage opportunities for small scale intensive agricultural or forestry activities within this plan designated area. That is the AFASH area. By admission, Mr. Etzel states this application is for a small scale winery and tasting room. The AFSH area is perfect for his application. The size of the two closest vineyards that Mr. Etzel and staff report refers to as being dominant use are both located a bit more than a mile away. One is 80 acres, surrounded by similarly large acreage vineyards. The other is 130 acres, very small, quaint red barn, and a small winery that one can't even see from the street. When comparing Mr. Etzel's application of 7 acres of vineyard with the idea of a winery and tasting room, this application is far different in scale. The vineyard is planted without any room for a winery and tasting room, parking lots, septic system, and other required entities that will decrease his vineyard size immensely. Exhibit 2, and if you could look at that, I would appreciate it. It makes one wonder if 3 years ago, when he planted his vineyard, he was not thinking of expanding to a winery, tasting room, and a home that he is now stating. I want to skip the next details of Ordinance 40204G of how we get to there. You could read that, or maybe you already have it memorized. The bottom line is Mr. Etzel's vineyard does not meet the criteria of a vineyard as described in 40210. Of course not. He has only 9 acres, not the required 15. Therefore, it falls under the last subsection, number 4. Number 4 states, a facility for production and sale of wine that does not conform to the attributes described in subsection 40210, I, number 1 through 3, may be deemed a commercial activity in conjunction with farm use pursuant to subsection 40204G. Pursuant is the key word there. 40204G must be applied and is listed under conditional uses. It states commercial activities that are in conjunction with farm use as defined in section 40210B, which means winery and other commercial activities, but not including the processing of farm crops, which are a permitted use as described in and under 40202E. In conclusion, 40204G allows commercial activities such as selling wine, wine tasting that are in conjunction with farm use, but precludes the processing of farm crops, which is a permitted use. Commercial activities are allowed, but not a winery. Therefore, this application should be denied as it includes a winery. Next section is incompatibility with the Yamhill Comprehensive Plan. Due to time, I will try to be brief. In essence, some of the important points are Mr. Etzel seeks to bring on 75% more grapes to be processed than what his acreage produces. Keeping in mind, once he has the building footprints of his winery, tasting room, proper roads, septic system, service vehicle parking, number of parking spaces actually required rather than the 11 that he states he will have. When you subtract the number of vines on his property to accommodate his buildings, it becomes even less. This is also requiring more water than necessary to process grapes grown on his property. The tasting room, and I have an error here on page 4, the tasting room will host up to 55 people per hour, as was clarified at the Planning Commission, as is stated in his application and is stated in the staff report. It is not per day, my error, drastic one. So the water use is going to be more than the residential use that has been customary in this vicinity. When increasing the water use, we have testimony, historical records submitted back in December, how the water availability was decreased when a neighbor irrigated his vineyard. for the first couple of weeks when he stopped irrigating the vineyard. Then the water came back for this particular individual. Our water here in this area is very close to being a critical low area. Our home and many others testified are examples of low water availability. Skipping some here. We are asking the county to acknowledge the conflicting uses of a commercial winery and tasting room in an area with historically low water use, and that information should be used as one of the deciding factors against this commercial activity. I'm going to skip more of the water and get down to the preliminary site development plan requirements. These have not been met. The site design that was submitted is a scale of 1 inch to 40 feet. It is up to the staff report or staff director to decide what scale to be used. He used that scale, but it's very difficult to visualize. Therefore, I enlarged particular sections, keeping that same ratio. Skipping down, one of the plan requirements is identifying trees in the area, 8 inches in diameter at 5 feet high. Mr. Etzel states that no trees will be removed, period, on his property. When you look at Exhibit 4, these trees are exactly where he intends to place his home. It's impossible not to take down trees that are 8 inches in diameter at 5 feet tall. On page 6, all proposed structures, including finished floor elevations and setbacks. On the submitted site development plan, one large rectangle south of the proposed single-family residence is not even identified. I don't know if it is a building, concrete slab, or whatever it is. Vehicular pedestrian circulation patterns and parking, loading, and service areas are not identified on this site plan development. Skipping a little bit more, it is noted that on Mr. Etzel's initial application, he acknowledges that there is no septic system. Staff report states on page 5, the county sanitarian shall inspect the current septic system to determine its adequacy and serve the new use. A new septic system may be required. Indeed, the septic system was used while the home was there and was destroyed when the septic tank was removed and when grading the vineyard in year 2017 by Mr. Etzel. These are conflicting and false information. More important than the inconsistency regarding the presence of a septic system or not is the lack of consideration on the site plan for a septic system. Mr. Etzel's application states there is acreage for, quote, tractor headlands, building footprints, and driveway. According to the site photo, the property has a small tractor width as shown by the worn earth tire tracks. Approximately 15 feet wide perimeter encircles the vineyard. Bare land to build upon does not exist as Mr. Etzel stated it does. Exhibit 5. Page 7. Up above the beginning of page 7, I'm going to make this shorter. I am demonstrating when a septic system is put in per sanitation department that I spoke to. In essence, it moves the whole home, the unidentified rectangle, the garage, all moving towards the south, towards the vineyard. Bottom line is 24 feet to the south of the northern vineyard line will finally be where the vineyard would be located should a septic system be put in and should the current gravel road, which is seen on those photos, should that gravel road be the 20-foot required road for this development. There is no cleared land for the winery tasting room, 19 parking spaces, not 11, as per in Yamhill County Ordinance 100702. And I'll get to that very quickly. Also, fire truck turnarounds, winery and tasting room septic system as well, service truck road, and parking space for the winery. Contrary to what Mr. Essel states in his application, currently planted with vineyard with the remaining acreage reserved for tractor headlands, building footprints, and driveway. I covered that earlier, sorry for the redundancy there. So the same distortion pertains to the winery. Per the site plan, the scale of what I enlarged remains the same ratio, and it is a ½ inch equals 20 feet. The winery measures approximately 2,400 square feet using this scale, instead of the 2,800 square foot that is stated that it will be. Constructing the winery, septic system, house, garage, tasting room will require loss of vineyard that is currently planted. See Exhibits 6, 7, and 8. The requirement according to Yamhill County Zoning Ordinance 110104B2 has not been met. Turning to the parking spaces. Yamhill County's Ordinance 100702 on the staff report of page 7. All applicable areas of this ordinance are to be considered in this application. Parking and vehicular patterns are defined and required for uses specifically listed in Yamhill County's Ordinance 107. Tasting room and winery are specifically listed in section C of this ordinance. Mr. Etzel states that he calculated the number of parking spaces according to the actual tasting room where his guests will be. He omitted bathrooms, office space, and storage of his own admission. He concludes he will have 11 parking spaces, which is shown on his site development plan. However, the ordinance 1007 states where square feet are specified, and it does because it singles out tasting room and winery in section C. The area measured shall be the gross floor area of the building or structure primary to the functioning of the particular use of the parcel. Therefore, when you take the gross floor area of the winery, tasting room specifically, is 1,800 square feet, plus one more for an employee. 19 parking spaces are required, not 11. More vineyards will be taken away to adapt to this new figure of 19 parking spaces. Again, the parking spaces for service vehicles and trucks is not on the site development plan. More vineyards will be lost. It does not have any service drives, which are supposed to be different than what the public will use. More vineyards taken away. Requirements under Yamhill County's Ordinance 107 have not been met. The vagueness of information and lack of specificity renders this preliminary site development plan incomplete according to Yamhill County's Ordinance 1101 and 1007. However, one can conclude by the submitted evidence that a significant amount of grapes must be removed to build the proposed buildings, meet road standards, parking standards, and septic requirements. With the removal of vines, less grapes will be processed. Less grapes processed, then less cases of wine can be produced from the property. The importance comes at that point. Removal of vineyard, agricultural, for commercial building on this acknowledged Joy soil is contrary to the comprehensive plan, which strives to prohibit or limit urban uses on agricultural land in order to utilize and maximize the agricultural land. We are not looking at an application here with 7 acres of vineyard. We are looking at a commercial winery going in, tasting room on this land. The application is not consistent with a comprehensive plan, nor have many of the criteria been met. False statements have been made regarding availability of bare land, tasting room, home, road, septic system, and so on and so forth. In turning to the application of Mr. Etzel, page 2, the exclusive farm use district, prior to establishment of a conditional use, the applicant shall demonstrate compliance with the following criteria in addition to other requirements of this ordinance. The use will not force significant change in accepting farming or forest practices on the surrounding lands devoted to the farm or forest use. Mr. Etzel has not demonstrated that the winery and tasting room will not force a significant change. Please read his explanation on pages 2 and 3 of his application. He does mention the winery and tasting room. However, it is the use of those that this ordinance is referring to. It is his burden to show that it is not in compliance with. It is not our burden to show that. Criteria 1 has not been met. Number 2, the use will not significantly increase the cost of accepted farming or forest practices on surrounding lands. Mr. Etzel replies to this stating, no change will be made to the current vineyard farming practices during or after construction that would cause financial impact to the neighboring area. Again, he does not address the use of the winery and tasting room. As if it's not even there, he only addresses the use of his vineyard. Criteria has not been met, number 2. Yamhill County's ordinance 1202. The use is listed as a conditional use in the underlying zoning district. Mr. Etzel cites Yamhill County zoning ordinance 50103, which addresses only those in the very low DR district. Forgot what the DR stands for. Very low development, whatever. Forgot it. Doesn't matter. Criteria A has not been satisfied. The use is consistent with goals and policies of the comprehensive plan, which apply to the proposed use. Mr. Etzel states the development will bolster local economic goals by introducing another tasting avenue. He states that Warden Hill is becoming one of the most frequent trafficked roads for wine tasting in the Willamette Valley. We certainly agree. Warden Hill Road is becoming one of the most frequently trafficked road in the Dundee wine area. However, Mr. Etzel, in answering this goal of the comprehensive plan, he never referred to its goals or its policies. He just gave a description of how Warden Hill is busy. We know that. Criteria B has not been met. Parcel C, the parcel is suitable for the proposed use, considering its size, shape, location, topography, existence of improvements and natural features. Suitability is a subjective term and could be judged differently by individuals coming from a different point of view. Webster's dictionary defines it as being appropriate for a particular situation. We believe it is not appropriate for this residential area. Even if it is zoned EFU, it has been residential and it will continue to be residential, hopefully. Mr. Etzel has described his proposal, its location and size, but has failed to show that it is suitable, appropriate for this residential area. Again, he compares his proposal to surrounding areas of vineyards and tasting rooms. However, as I will show later on, the mileage of being affected by this being in compliance or being as the same of does not exist. He has not demonstrated suitability. Criteria C has not been met. The proposed use will not alter the character of the surrounding area in a manner which substantially limits, impairs, or prevents the use of surrounding properties for the permitted uses. Mr. Etzel states, the proposed use is harmonious with neighboring properties on Warden Hill Road. Surrounding areas include vineyard, tasting rooms, and farmland. Again, the surrounding areas do not include tasting rooms. Vineyards are large, 30 or 40, 80, 130 acres. That is the surrounding use of vineyard description. Criteria D has not been satisfied. He has failed to demonstrate that the use will not alter the character at all. Again, he just gives definitions. C or E, the proposed use is appropriate considering the adequacy of the public facilities and services existing or planned for the affected use. Again, Mr. Etzel has not demonstrated the adequacy of Warden Hill Road as being sufficient for the additional traffic brought to this area as a result of his winery and tasting room. The traffic report and TSP show the adequacy of Warden Hill Road to be hazardous, and this statement is addressed under the traffic report section of this response. See Exhibit 9. The TSP particularly shows from north of Fairview Drive, south along Warden Hill, down to Crabtree Park as being one who lacks culverts. They do not have any shoulders. It is barely wide enough, and it is known as a minor collector road. The ramifications of being a minor collector road will be covered in a little bit. Mr. Etzel states that the well on site has ample capacity. He has not provided any proof of whether or not it has ample capacity. If anything, the demonstrations of the neighbors nearby have shown otherwise. His capacity of the well and the flow rate is not up to date. I spoke with Herb Coons, who has lived in that property for at least 35 years. He states his well always got 8 gallons per minute. I have spoken with the fire department. They also would require sprinklers in the buildings, and they do not want to be reliant on a well that is producing even 10 gallons per minute. Criteria E has not been met. The use can be or made compatible with existing uses and other allowable uses in the area. The existing uses, at least 1 mile away and up to 2 miles away, is what Mr. Etzel compared his use to. Obviously, 1 mile and 2.5 miles away is not the surrounding area. He does not address the existing close proximity of residential use. Criteria F has not been satisfied. 1 and 2.5 miles away is not surrounding areas. Turning to Yamhill County's Ordinance 1101-02, characteristics of adjoining and surrounding uses. Mr. Etzel states neighboring and surrounding properties include vineyards, wineries, tasting rooms, and residential lots. The use is people living here, and we've have many people living here who've been here 30 and 40 years. We have shown this to be contrary, number one, to the facts previously presented. Interesting that he refers to only lots instead of residential neighbors. He's trying to eliminate the idea that this is a residential area. Again, the surrounding definition of 1-2 miles away is not appropriate. Traffic study. I'll address that in a bit. Natural features, we've addressed the tree issue. He says that no tree greater than 10 inches will be removed from the site to build his home. Again, look at the exhibit pictures. Comments, recommendations of the adjacent vicinity property owners who may be affected. Mr. Etzel writes, and it was shocking to all of us neighbors who read this. At the end of his application, the very last statement is, the proprietors have communicated the intent of the project with all surrounding neighbors and have not heard any negative feedback. Upon receiving notice of this proposal, the neighbors conferred with one another as to whether they were contacted by Mr. Etzel or by Mr. Labunsky. The adjoining neighbor to the north has a recently made easement with Mr. Etzel created to allow a construction access for the home currently built. We assume he knew about the project, and out of respect for him, our neighbor who has been here equally long, he was never asked about being contacted by Mr. Etzel. We did not want to put him in a position of embarrassment. 13 neighbors on Fairview Drive and north on Morden Hill, in very close proximity to Mr. Etzel's property, were not contacted, and we have yet to find anyone who was. Discrepancies, disagreements with staff report. On December 22nd, we received the staff report, gave us 2 weeks to digest, research, and present our opposition to the report. Christmas, New Year's, and weekends included. And I should add, my husband and I both had COVID for 3 weeks during December. However, that's okay. After calling a few of the departments, Watermaster, Dundee Fire Department, the same answer as to why they did not respond was given. The answer was, because this is a land use application and until it is approved, no response is necessary. Therefore, the fact that most departments did not respond is absolutely meaningless. The staff reports also states that the agricultural uses are dominated by vineyard, include grass and hay production. Number one, there is no grass and hay production around here. Number two, the agricultural uses are really not dominated by vineyard, but rather by the uses is the residential area and the different farming that they have there. Conditional use provision and analysis. The use is listed as a conditional use in the zoning district. We go back to the zoning ordinance 40204, listing commercial uses, which include wineries not listed as a permitted use, subject to design review standards. When using any ordinance or statute, one cannot restate it, as was done in the staff report, and only use the portion that supports your position. One must use the entire language of the entire ordinance or statute. The entire 40204G ordinance states, as I have covered before, not including the processing of farm crops, which are a permitted use, not the conditional, the permitted. Conditional, if you have 15 acres or more, yes, that you could then process the grapes. Less than that, all you get is the activities associated, but not processing. When applied, this winery cannot be approved under this statute. Staff report states regarding the comprehensive plan that the Yamhill County goals and policies do not provide specific standards for review of wineries. Very true. However, the goals and policies are not intended to address specific standards, but rather serve as a guideline for making land use decisions. The staff report says because it doesn't have the specific standards for review criteria of wineries, it really isn't even appropriate. We disagree. As a result of the threat of expansion of urban development, Yamhill County has recognized the AFSH land, which I referred to before. That is the land that enables the small-scale agricultural activities to be sited. And Mr. Etzel's application would be allowed in such a land. Yamhill County Goal Statement 2 Policy. Yamhill County will continue to recognize that the appropriate location of very low density residential development is in designated large areas where commitment to such uses have already been made through existing subdivision partitioning for development and by virtue of close proximity to existing urban centers, or small limited areas having unique scenic, locational, and other suitable site qualities where the anticipated magnitude or density of development is not such as to require more than a very basic level of services, such as a single local road access, individual domestic well and sewage systems, and possible rural fire protection. This policy describes nearly word for word the residential area that was partitioned in 1892. It includes Mr. Etzel's property, known as Lot 2. Changing the character of Lot 2 from residential to commercial is not being consistent with the previously partitioned and developed residential area since 1892. The magnitude of Mr. Etzel's winery and tasting room, which anticipates 55 people an hour, is large. At any place, it's large, but especially in this residential neighborhood. 2 miles away, Warden Hill Road is already experiencing parking on fields during their events, not on the road, not in parking spaces, parking on fields. Cars slow down to figure out which way to go when the speed limit is 45 miles per hour. During harsh weather, this last winter, 2 vehicles slid off the road into the brambles, fortunately not into the Marish Vineyard. However, they slid off into the brambles because they do not know how to drive when it's icy on the hilly rolling roads. This is the result of urban expansion into this EFU land. Staff reports, page 8, states 55 patrons a day will be visiting, and therefore a, quote, slight to modest increase in traffic from employees, deliveries, and customers will be generated by the proposal. The correct number of patrons visiting, 55 per hour, he quotes it as 55 a day. We totally agree 55 a day is a modest slight increase. However, it is 55 an hour. Obviously, that's a huge increase in traffic. Moving to the traffic report, the site development plan includes evaluation of traffic safety. It is the responsibility of the applicant to provide a traffic study in such an application as this, with the expectation of 385 patrons a day. Twice the county provided a partial traffic report, which only studied volume and speed. It did not study the adequacy of the access, of the egress, of the nearby, very close, within 30 feet, intersection of Fairview Drive and Morden Hill. The discrepancies of the traffic report were reported to the Planning Commission without a response or acknowledgement from the Planning Commission. We find this very disappointing that the Planning Commission observed these discrepancies, which were horrendous. They're in the report, but it was up to 100 cars a day that was, as they cross the counter strips, the most southern counter strips, there's no way to drive off that road prior to crossing the northern counter strip. And there was 100 car discrepancy. The Greg Hefner pointed out one day had a discrepancy. Why didn't he point out, like I saw and many other neighbors who viewed this traffic report, and we had one day to view it before we went before the Planning Commission? How come he didn't point out every single day had a discrepancy? That traffic report was so erroneous that a second traffic study was performed in February, and that report is in the application packet. The second traffic was performed during the week of February. I should state now that these reports are in the winter. Is this reporting the normal traffic experienced in the summer, the fall, the spring, when wine tasting is at its peak? Of course not. The study was done in winter when it is far less than summer. Also, COVID restrictions were in place, so less vehicles on the road when under even normal circumstances. Nevertheless, the counts are such that we understand why the TSP labels Warden Hill Road as a minor collector road. Staff report says it is a local county road. It is not. The speeds of the vehicles shown on the report do not reflect the true speed that is on Warden Hill Road. Please see Exhibit 10. You can see the placement of the counter strips are way past the sign that says slow down 20 miles an hour to navigate this curve. Counter strips were placed outside the sharp curve. Southbound on Warden Hill has a warning sign. Counters were placed well after, south of that warning sign. When crossing the counter strip, the northbound traffic is accelerating out of the curve, going up. Thus, the speed of the vehicles traveling along the straight section of Warden Hill Road along Mr. Etzel's property is greater than those speeds recorded. What were those speeds recorded? A traffic engineer explained to us that the peak daily speed of 85% is reflecting that 15% of the vehicles were traveling faster than the peak daily speed. So the speeds of 37.1 and 38.9 miles per hour associated with the results of the study reflects what the speed was while navigating that curve. That's how fast these cars are going on Warden Hill. On the straightaway, before they have to brake, and on the straightaway, as they're now accelerating, was never studied. The allowed speed of 45 miles per hour per the TSP standards influences driveway placement, adequacy of the road. In other words, the width of the road, the need for shoulders, the need for culverts. None of that is in the Warden Hill Road as it stands right now. It projects as in one of my exhibits there has a picture of what the TSP has planned for this particular section of Warden Hill Road to be accomplished. I believe it was starting in year 2030 something. A thorough traffic study by Mr. Etzel, the applicant, is warranted due to the number of planned public expected for the tasting room. Right now, not now. Any large delivery truck exiting the property at the proposed southern exit will enter on Warden Hill Road. As posted on Warden Hill Road near 240, delivery trucks are limited on this road and would turn right all the time out of the property, returning to Highway 99. The large trucks making their deliveries to the winery must encroach upon the northbound lane in order to navigate the sharp turn, turning right out of the property and immediately turning left into the curve. This would take great maneuvering and would be traveling at a slow speed. Vehicles will also find this right-hand turn then left a bit quick maneuvering. This appears to be a dangerous exit site. Beside that, there is a neighboring driveway. According to AASHTO, 2 driveways that close together is not allowed. Stopping distances, driver requirements, and more render this application not safe regarding access and egress. In addition, the current driveway that Mr. Etzel created 4 years ago appears to be unsafe as it is now. It is not the original driveway, which was appropriately in the middle of the straight section of Warden Hill. The current driveway is the 3rd access onto Warden Hill within a close distance to each other. The current driveway is also an easement being used for the construction of the house behind Mr. Etzel's property. Heavy equipment trucks have been using this dangerous entrance and exit for a few months, going unnoticed by the county. After a heavy rainfall, gravel spills onto Warden Hill because there are no culverts, creating a slippery road. Adding more traffic to this already dangerous section of the road should not be allowed. This application should not be approved. Mr. Etzel's evidence submitted during the open period. I will not discuss how his evidence was accepted by the planning department in the week of rebuttal or argument. It was done, it was wrong, and it's over with. Mr. Etzel, in his exhibits that he titled January 21st, I will not go through them. I think I've addressed most of them. However, relating to comments of the adjacent and vicinity property owners is another situation that deserves to be discussed, but is absolutely not pleasant. Notice was given of this proposal during November. We filed an appeal of the approval. November 23rd, Mr. Etzel came to the home of Jerry and Elizabeth Seeberger unannounced. He shared his dream as he described it. I welcomed him into our home. We sat for over an hour talking. He was concerned about the opposition of the neighborhood. And frankly, during that conversation, he related a conversation that he had with very dear friends of ours that we have known for 15 years and presented this man, Tim Ramsey, as being in support of his application. Because of knowing Tim Ramsey for 15 years, we knew differently, but I let him talk about what Mr. Tim Ramsey supposedly said. At the end, I said to Mr. Etzel, I have known Tim for 15 years. We communicate, we socialize weekly. You sure Tim Ramsey really said all of this? At that, Mr. Etzel said, well, he was nice. And I said, being nice does not mean he is in support of your application. So I'm going on now. The idea of mediation was presented to him by me. He could not think about a way to mediate I gave suggestions to him. After an hour, he left stating he would call. Cell phone numbers were exchanged. He never contacted the Siebers again, nor any of the opposing neighbors. However, the closing statement from Jared Etzel, the last paragraph is, the appellant, that's me, is attempting to have my strong arguments removed from the record. This speaks to the reason that she opposes my project, which is anti-development. If I attempted to remove any arguments or anything from the record, it would have been documented. My husband has been an attorney for over 35 years. I respect the law. I am honest. And if I had done that, I know it would have been in the record. I have addressed, I'm quoting him, I have addressed the appellant on multiple occasions to reach a conditional mutual agreement and have not seen any concession. Beside not even understanding what a conditional mutual agreement and how I should be having concessions, more importantly is this. This statement is as false as any other statements made to Mr. John Bridges. Please read his letter. The attorney, John Bridges, is a neighbor here. The statements made to the planning department regarding no negative feedback, regarding he has plenty of room to build the winery tasting room, there's bare land, the attempt to remove arguments, and now this most meaningful and absolutely false statement regarding the attempt to contact Elizabeth to reach a mutual agreement. Meaningful because in November, Elizabeth suggested mediation to Mr. Etzel. I emailed the neighbors about this conversation. Exhibit 11 is that email that I sent to the neighbors that very evening, and I described the truth of what went on. As seen in this email to the neighbors, he was spoken of with respect by me, and indeed I complimented on his love for this area. I welcomed him into our home. I spoke with him for 1 hour. I suggested mediation. We exchanged phone numbers. He never contacted me or any other neighbors. There's no animosity towards Mr. Etzel, but falsely accusing and not wanting to mediate necessitates exposure to the truth. The neighbors wanted to mediate, and we were waiting for Mr. Etzel to get back to us. This concludes our submission of opposing this application.
Thank you, Ms. Seeberger. Appreciate that. At this time, we'll move on to other testimony in opposition to the application. And I will ask that if anything that was already addressed by Ms. Seeberger is in your testimony, that you acknowledge that and either just say you're in opposition to the application or that these comments were already addressed by Ms. Seeberger so that we can address the timeliness of the hearing. So at this point, is there anyone in opposition to the application? And if you could tell us your name and your address for the record and let us know if you are, looks like Ms. Jernstad is ready to go. Ms. Jernstad, yes, if you could give us your name and address for the record. And again, if you could keep your testimony to under 3 minutes, and if your comments have been made prior to this, that you just acknowledge that for brevity. Thank you.
Thank you, Chair Starrett and Commissioners. My name is Catherine Jernstad. I'm representing Friends of Yamhill County in this matter. We sought to be named in the original request for hearing as well as in the appeal. With all due respect to some very strong feelings on the part of the neighbors, we do have a slightly different position behind our opposition to this. We do not necessarily agree that these antiquated plats are either rare or definitive in land use issues. What we would assert, and again, Friends has previously provided testimony on this and other applications for commercial uses in conjunction with farm use, quite frequently wineries and tasting rooms on small parcels in exclusive zones. There's no small amount of truth in what Planning Commissioner Abrams observed in the deliberations about the cat being out of the bag, but that does not rise to the level of illegal precedents. Etzels are prominent individuals in the local grape business and held in high regard, but the neighbors are also deeply invested in the impact on their homes. Again, this mention of mediation, the Board of Commissioners has in the past used your authority in the conditional use process to impose limits and restrictions, conditions to mitigate those raised by the community. In the case of the Colwell Winery, it was a county imposed a 500 annual case limit on a 6.17 acre parcel. Varnum, it was a 2,000 case limit on a slightly less than 5 acre parcel. These conditional use permits need to be considered on a case by case basis. In this discussion here, it appears to be a conflating of viticulture versus winery activities and tasting room activities. In the case of Firesteed, this was controversial to some in the wine industry itself because they were not doing grapes. So I think we have an opportunity here, although we are facing a dreadful timeline, that this application could potentially move forward, but scaled more appropriately to the region in which it operates. And by this, we aren't asserting that it's a violation of lot coverage standards. We use a broader discussion about build out, refer to the proportion of grapes produced on crop produced on site versus processing capacity. And I think we've had unresolved issues regarding numbers of people in the tasting room at any one time. And, he talks about not being traffic because it'll just be drive-by, but then also that there'll be by attention. And does that mean you stop in front of the driveway and call to make an appointment before you turn in? My understanding of the conditions as it came out of the Planning Commission is it's 55 visitors to the tasting room at any one time. There were discussions about limiting total over the course of the day, but they don't appear to have survived deliberation process. Others have stated the issues with the traffic study and that a traffic count in the winter months in the time of COVID should be viewed with a certain amount of caution. Another element, and again mentioned, is the neighboring farm operations. Excuse me. Harvest time. I've spoken with someone who hauled grapes up there, and that kind of activity, excuse me, potential conflicts with the tourist traffic. Again, this operation will not exist in isolation. Again, with the Etzel family connections, he would not have any trouble bringing grapes to the site. The question would be the appropriateness and the impact on the neighborhood. And again, I mentioned parking spaces at the hospitality facility. Again, he asked for a fire marshal capacity rating, which again is going to raise issues of sprinklers. And I'm not sure how we're going to spread out 55 patrons among 10 parking spots without there being buses or other larger scale vehicles involved. And in our open record submission from Friends, we did offer some modified conditions that we believe are appropriate in this situation. I mentioned the problem with the audio during that Zoom meeting, and I think that these proposed conditions merit review. There's also the issue of the replacement dwelling, and in the applicant, they talk about it being a shared occupancy between the two owners. Permitted dwellings in farm zones do not include vacation rentals, and we proposed a specific condition of approval that stipulates that the dwelling will be only occupied by an owner or other person engaged in farm operations. I think that merits addressing in the specific conditions. Again, I mentioned the what seems like an apparent contradiction between by appointment but drive-by traffic, and the extensive open hours. We've had difficulties in Wolves and People where a lack of specificity in the hours of operation have created unintended consequences and problems for the neighborhood. Again, my letter talks about a few other issues, but I would close or wrap up kind of with the notion I wouldn't be Joel Lamb for any amount of money. I understand the county's reservations about addressing water issues. And Joel gets quoted in any number of ways, but I would point out that a water right does not put water in a well. And the exempt well is limited to one conditional use. And is that conditional use irrigation of the crop? Is it operating the winery? Is it having the tasting room? So that these are more complex issues. And I believe that really the only way forward on that is in the same manner you did with the other ones I mentioned, limiting the winery capacity to more appropriately match water availability and crop on site. Again, and I encourage you to read the material in the packet. I think she's left now, Ms. Lundeen said something about the additional testimony had not been sent to you folks yet. If that's the case, Casey says something about.
Sorry, Chair, we received it from Desiree during the meeting because it was not yet.
Oh, correct. And that really was pretty much revolved around the de novo decision. So.
Oh, no, sorry,
Okay.
Chair. There's a multiple comments. One of them is from Elizabeth Seeberger, which is basically what she read today. And then another one is from Catherine, I believe. And then another one is the second traffic study results from Great.
Okay. All righty. Thank you.
Thank you, Ms. Again,
go ahead.
I encourage you to read it.
Thank you very much. Will do. Appreciate that. Thank you. Do we have anybody else who wants to make testimony in opposition to the application? Is there anybody who's in the queue to do that? None at this time. Okay. Let's see. Anybody?
Chair, I just want to note thank you to, Catherine just left. Thank you, Catherine.
Yes, thank you, Catherine. Alrighty, appreciate that. All right, at this time, since we have no other testimony in opposition to the application, we'll go to public agency reports.
Hi, Commissioners. So we will go ahead and jump right in. Staff reached out to referral agencies and received comments from the Yamhill County Engineer, City of Dundee, Oregon Department of State Lands, and Oregon Water Resources Department. Yamhill County Engineer Greg Hafner submitted a referral for the Commissioner's considerations on January 6, 2021, which states in part, Public Works has reviewed the application from Jared Etzel, docket C22-20-SDR-2620 for approval of a conditional use and site design to construct and operate a winery and tasting room. We performed a field investigation to confirm adequate intersection and stopping site distances and concluded that based on field measured information, the access points in and out meet AASHTO guidelines. Grade and speed were utilized to confirm adequate distances. We also performed a database search of ODOT's GIS website and concluded that there was only one property damage crash within 0.5 miles of the site reported. In conclusion, this site appears to be safe with no history of crashes and also meets stopping site distance requirements. And as previously pointed out, additional information was sent to staff from Mr. Hafner on March 1st, 2021. This information was forwarded to the board today following the motion to hear this matter de novo. It also has been mailed to both the applicant and the appellant. The City of Dundee provided comment that they reviewed the file and found no conflicts with their interests. Department of State Lands provided comment stating that there are no state wetland and inventory features mapped on the subject parcel. District Water Master Joel Plon provided a comment on behalf of the Oregon Water Resources Department, which provided clarification and guidance to the appellant and surrounding property owners about exempt uses of groundwater, priority dates, and water level data from the Etzel well. That concludes that portion.
Thank you, Desiree. I appreciate that. So we'll have a rebuttal by the applicant, Mr. Etzel.
Yes, thank you. Can you guys hear me okay?
Yes.
Perfect. Addressing the appellant's site plan commentary, the site plan was done by a professional surveyor and is accurate, in fact. The circulation road as proposed is 20 feet wide. The septic system, which has actually been turned in, the plan has been turned into the county and the placement has been approved. They dug the test pits already and it's placed in between the headlands, which are in between blocks of the vineyard. So not removing any vineyard on the septic system at all. It fits entirely in those inner headlands. The scale of the buildings, I guess first to address the house is designed to be on stilts and to nestle right up against the trees. And we've actually surveyed every tree in the 1 acre portion of where the house is proposed. The shape of the house, as seen in the site plan submitted, is shaped so that it fits within the forest, and there won't be any tree removed over 10 inches in diameter. It's actually, I guess, immaterial really to the docket, but just wanted to defend myself on that. Regarding the tasting room space, the code as I received from Ken Friday, and the requirement is for every 100 square foot of tasting room specific space, so area where the tasters will be hosted, requires one parking space. and we have exactly 1,000 square feet in the proposed drawings done by the architect and exhibited on the site plan. And there's a small outdoor area where tasters could be hosted. That's separate from the 1,000 square feet. And to my understanding of the code, and Ken can correct me if I'm wrong, but that outside area doesn't trigger more requirement for parking space. So we've got 1,000 square feet, which would be the 10 parking space, and then the proposed area for the employee parking is on the crush pad of where the winery is. So they would be that's covered. We have ADA code parking included on the site plan, and the footprints of the winery and the hospitality building would take out less than 0.3, 0.4 acre maximum of existing vineyard. So the net vineyard, net vineyard is another interesting calculation if you get into the detail of it. Often when, from my understanding, the county's calculating it, it includes the headlands and the roadways. My calculation stated on my site plan is my exact net area of vines planted and even excludes the inner headlands. So if I included my inner headlands and turnaround areas, it's going to be above 7 acres. And the building footprints would certainly not take out more than 0.4 acres. The roadway is already existing around the perimeter of the building to meet the 20-foot code requirement. And so the appellant's statement that the vineyard is dwindling down to this microscopic thing is incorrect, because there's going to be very, very close to or above 7 acres if you include the inner headlands. Let's see, to address the capacity issue or question of the building. So the 1,000 square foot area in our tasting format is to be by appointment. We were requesting a maximum capacity of 55 visitors at one time. It's certainly not at 1 hour. And that's a maximum capacity, which we just want to have that capacity in order to be within our permit and be within that that allowable amount. We don't see ourselves operating regularly at 55 visitors at once. That's just the allowable maximum. And so I don't feel that will trigger a huge traffic issue. And that should cover my end of arguments. I'm going to hand it over to my attorney, David, for some quick points. Thank you guys very much.
Thank you, Mr. Etzel.
Thank you very much. Hopefully I can wrap this up pretty briefly.
Oh, I'm sorry. There was one more thing that I'm sorry to butt in.
It's okay.
I wanted to address the water use, and that we are not irrigating our vines at all. There's no irrigation system. And we certainly feel like we could comply with the exempt use of 5,000 gallons. So, all right, this time for real, I'm handing it over. Thanks.
Thank you.
Thank you. I'm going to try to. There was quite a lot of testimony from the appellant, and I'm going to try to kind of distill out of it some of the issues I think that raise legal issues, which is really why I'm here. And so just try to make our record on this on a few legal points. Early on in her testimony, the appellant used phrases like dominant use to describe the residential area, and she also characterized Mr. Etzel's proposed project as urban development. first of all, a winery and a wine tasting room in a agricultural zone is most certainly not urban development. That is a commercial use associated with farming, which is exactly what your code provides. Talking about the dominant use being residential, even if that is somehow true, what that effectively is an argument kind of to rezone this property in this area for residential. And the fact of the matter is, if that's what the applicant think or the appellant thinks should happen, then she can make an application or she can convince the board to consider that as a legislative matter. But as this stands, Mr. Etzel has his investment-backed expectations in the property based on the zoning of the property when he bought it and as it existed when his application was deemed complete. And the fact of the matter is it's zoned EF20 for agricultural use. Wineries and tasting rooms are either a permitted or conditional use in that zone, and those are the criteria that apply. She may wish that the property area is zoned differently, but at the moment it's not. And so that's this board's decision-making is limited to applying the existing zoning. She also talks about the conditional use approval criteria on 1202.02D and also the general impact criteria that you have for any application in a farm zone about limiting adverse impacts on nearby farm and forest uses. The key phrasing there, of course, is farm and forest uses. So the evidence submitted and the evaluation done by staff and the Planning Commission is more than sufficient to demonstrate that this proposal will not have adverse impacts on nearby farm and forest uses. In the conditional use criterion, it uses the phrase permitted uses. Again, permitted uses in this zone are not non-farm residential. Permitted uses in this zone are agricultural uses. Ms. Seeberger suggests that if a winery is not a permitted use in the EF20 zone under 402.10I4, then it is not a conditional use because it's the processing of farm crops. That's just plainly contradictory to your plain language of your code. I direct you to 402.10I4, which specifically says that a winery that does not meet criteria for permitted use can possibly be permitted as a commercial activity in conjunction with farm use. Ms. Seeberger raises numerous challenges to the site plan and also the application of certain comprehensive plan policies. I would note that neither of those grounds for appeal were raised in her notice of appeal and accordingly are beyond the scope of this appeal. As to the site plan itself, she has many complaints about the site plan and describes the site plan in a lot of ways that are not apparent on the site plan itself. All you have to do is look at the actual site plan to see what is proposed and what is approved. And assuming the Planning Commission's decision stands, the site plan that Mr. Etzel can implement is the one that's approved. And that one, as Mr. Etzel explained, shows very limited, if any, impact to the growing grapes on the property. Lastly, I want to respond to the representative of Friends of Yamhill County. She talked about the potential use of the home as a vacation rental. My clients tell me that that's no longer their intention. The intention is for Mr. Etzel and his family to occupy the home full time. Nonetheless, the home itself is not the subject of this land use application. The home is the subject of a completely different land use application. And I understand from the staff report that there's a permit that's going to expire sometime in August for the reconstruction of the home that was demolished. So conditions of approval relative to the home are not appropriate for this application, which is of course for the winery and tasting room. Ms. Jernstedt, I believe is her name, she said that water rights do not put water in a well. Well, that's certainly true, we all know that, but that's precisely why we have the Oregon Water Resources Department to resolve issues of that sort. So water issues can be taken up with the Water Resources Department, and if they think this is a groundwater deficient area, then they have processes and rules that apply. It's not a subject for this land use matter. The scale of the winery, I think Mr. Etzel in his initial testimony spoke very adequately about why this winery is adequately sized. It's definitely less than proportional to the production that would be allowed on a 15-acre winery. And then the last point I want to make is a lot of people have used the phrase traffic study. There is no traffic study in this application. There was no obligation to produce a traffic study in the original scoping of the application. Nobody has written a traffic study. A traffic study typically talks about the anticipated traffic impacts from a proposed use. What we have here is traffic counts, accident data, and measurements of site distances, all of which have led Mr. Hafner to conclude that traffic is not an issue for this application, and that is still the only evidence you have on the record. Now, I haven't reviewed Ms. Seeberger's submission today. Obviously, I will do that in the next few days and respond if appropriate, but at the moment, the only evidence you have leads to the only possible conclusion with respect to traffic, which is that this development does not present a traffic issue. That's all I have. Again, I'm happy to answer any questions.
Thank you. Commissioners, questions?
Thank you.
I may have.
Okay, Commissioner Kula, go ahead.
Yes, thank you, Mr. Peterson, right?
Yes.
Okay, so my first question for you, I don't have many, so don't worry, Chair, I should say. But the one thing I wonder about is, I know that many of these rural roads have traffic accidents on them, have collisions, have slides off that never rise to the level of getting onto an ODOT survey or data pool. Our county project engineering project manager still recognizes that and says that it's a road that can handle the traffic. Given that there often are crashes that we don't know about, do you still feel comfortable that this site and this project can go forward, given that there are likely more collisions than we have listed as that one?
Well, I'm certainly more comfortable. I'm certainly comfortable that the project can go forward and not contribute in any adverse way to safety. I would point out that if there are in fact accidents happening and they're happening at an above average rate, that's not a consequence of my client's project. That's a consequence of how the road system is designed. And my client is not the county road department. So, you know, if changes need to be made either in the design of the road system or the posting of the speed limits or what have you, that's a county road planning issue. That's not a land use issue for a specific use. You know, potentially a conditional use is responsible for improvements necessary to address increased traffic that use will generate. We haven't demonstrated that this use will generate any kind of meaningful additional traffic. So those kinds of issues are beyond the scope of conditions that could be imposed on this permit.
Okay, thank you.
Commissioner, did you have another question?
You know, I actually looked at the questions that I had generated, and I think that Councilor Peterson actually answered them already. So
thank you.
Thank you.
Commissioner Berschauer, questions?
Thank you, Chair. I had a full page of questions and most of them were answered, so that's awesome. Quick comment about the fear of having about 55 or so people per hour at the tasting room. I'm a member of several wineries in our county and I have never seen 55 people there at one time, especially small scale wineries, so I don't believe that's realistic. If you get to that point where you have 55 people crowding your tasting room, that's awesome, more power to you, but I don't think that number is necessarily realistic in terms of a fear going forward. Since some of us are not very knowledgeable about how water is used throughout your process, can you explain that a little bit more? This question's for Jared. You said you're dry farming, and I get the concept of that, but where does water come into the processing of the grapes, and what percentage you know, is used in the farming side versus the processing side, just for a point of clarification?
Yeah, certainly, no problem. So there's no irrigation of our vineyard at all, and the only water use in the vineyard really at all is the sprays that happen, and they're organic sprays. So we have around 9 to 10 sprays in an entire year only. And we're spraying 50 gallons per acre of water in combination with sulfur. So this powdered sulfur is our fight against powdery mildew, which is really our only disease pressure. And that's an organic that's an organic spray product. We don't use any synthetic, non-organic spray products at all. So the water use on the vineyard side is really low. The water use in the winery only occurs during harvest time, and it's really to clean the bins, wash the bins down, clean out the fermenters. It's really cleaning. Winemakers that kind of refer to themselves very often as glorified janitors that end up with a better product to drink at the end. But it's cleaning and washing things, and we will be well below the 5,000 gallon per day limit. We institute things such as water recycling when we're cleaning. We have a steam cleaner for the barrels, which drastically reduces the amount of water used. And as a preventative measure, we're installing underground holding water tanks so that we could build up some water for a higher use period and still be in a very good shape and not taxing our well. So does that answer relatively well?
Yeah, it does. And one of the concerns of the appellant was the amount of fruit that you would process from off-site. And I noticed in the Planning Commission minutes from January 7th, there was a reference to 20 tons of fruit would come from the winery. So I'm assuming that 20 tons is approximately 1,200 cases of wine. Is that the assumption? Okay.
Yeah, we normally say about 55 cases per ton of fruit.
Okay.
Yep. And the purchased fruit is, the 5,000 cases requested is what we would like to grow into. It's not what we're going to be producing immediately out of the gates. It's just enough wine in order to make this a financially viable business. It's been shown over and over again, and my accountants have told me, if you're under 5,000 cases, good luck making it in the wine business, because there isn't enough margin per bottle to support the business. So it's a tough thing because we need to be able to grow into that amount. But the amount I feel is still very, very small. My family's Beaufrere produces about 12,000 cases, and that's still a tiny winery. We're talking, the scale is very, very small, and we're talking about a very artisanal high-end product. The number of trucks coming in to deliver any of that purchased fruit, we're talking about 3 or 4 trucks in an entire year delivering the fruit. It's non-material in my opinion. That's
right.
kind of,
And that's what you've stated here too, is that roughly 60 tons would come in from offsite, which would get you to somewhere close to the 5,000 case mark. I guess my follow-up question though is, due to the size and structure of your winery, are you limited in what you can produce, or could you produce 20,000 cases? Is there something about the
building is the winery production facility is tiny. It's 2,800 square feet. I mean, most people's homes are larger than that, and it's in scale with that 5,000 cases. We've hired an architect that specializes in wineries, just really incredible stuff out of Sonoma County, and it's really the scale. We couldn't produce more than 5,000 cases in there, and nor do we want to. I think for us, the proposal is a perfect match of having enough scale to make a business out of it, not overburdening the area or the traffic circulation of the property. And it's a very good traffic circulation, actually, because it's a loop. And actually, the driveways were already approved by the county as well. They went and and looked at it, and I have a driveway permit. So I feel like the site design I'm actually really proud of, and our architect was really pleased with it too. In that I think that it doesn't pose any risks. There are ample parking spaces. It's meeting the code as I got it from Mr. Ken Friday, and shouldn't cause any issues. And there will not be a significant reduction in the amount of vines for construction, for parking, or for the driveway. It would be under 0.4 acres of vine removed at maximum. And I'm certainly willing to keep that in writing and not exceed it. Yeah, it could be a condition. It is a condition. So, and the 7 acres, like I said before, it's technically more than 7 acres. I understated it because I didn't include the headlands, which is allowed. So, thank you guys very much for your time. Are there any other questions?
Commissioners?
Chair,
Any
I
other
don't have any
questions?
further questions.
Any other questions?
No,
So
thank you.
at this time, and thank you very much, Mr. Etzel. At this time, Todd, can you weigh in on keeping the record open? If we were to do that, is there a request to keep the record open?
There has been no request to leave the record open at this point. The applicant has, or it's given an opportunity for the final word, and it may be that they believe they've already given that final word. If they didn't, we were going to propose, or Ken Friday and I talked this over, that the record be left open to the applicant, and this is only if they're requesting it, to submit final written rebuttal with no new evidence by 5 p.m. on Tuesday, March 16th. Because a pretty large packet of information did come into the record today.
Yes, can we do that, please? We would like that opportunity.
Okay, so we'll keep the record open until Tuesday.
Is that right, Ken? Did I get that right?
If you'd like, I can read it off and you can decide if you want to move this for approval. The record shall be left open for the applicant only to submit final written rebuttal with no new evidence until 5 p.m. on Tuesday, March 16th, 2021. The Board of Commissioners shall then reopen the hearing at 10 a.m. on March 18th, 2021 on Zoom at the point of staff recommendation.
Is that acceptable to everybody? Thank you.
That sounds great to me.
Okay,
and
thank
I'm
you.
happy to.
Somebody should move it. And
okay.
I was going to say I'm happy to make that motion. I move that we do what credit
Ken
just noted,
said.
which I believe is hold the.
All right, we're getting some audio problems. So the motion is to keep the record open until Tuesday for additional written testimony till 5 p.m. on Tuesday, and then we reopen on the 18th at the point of staff recommendation. We have a motion. Any further discussion? Hearing none, all those in favor signify by saying aye. Aye.
Aye.
Aye. The motion passes. So is there anything else, Todd, that we need to address before we adjourn the hearing?
No, Madam Chair.
Okay, thank you. Thank you, Ken, for being here, and Desiree, and everybody who provided testimony and information, and we will see you back here on the 18th. Thank you very much. We'll close the hearing. Thank you. And we will reopen at the point of announcements in the informal session. And do we have any announcements? Okay.
I just wanted to note, Chair, that real quickly, that I did speak at the Oregon Transportation Commission this morning, but I spoke on behalf of the Parkway Committee, which was authorized by the Parkway Committee. So I just want to note that I really wanted to be careful that I wasn't speaking for all of us. So I made that very clear.
Thank you very much, Commissioner. All righty. Ken, yes.
Yeah, my apologies, commissioners. I know we've had a long session today, and my apologies. The only thing that I just wanted to briefly mention and just put on the commissioner's radar of some upcoming that we're going to need to schedule some time for some discussions. And I did see that there was an announcement. It looked like the president did sign the latest COVID.
American Relief.
Thank you. I keep wanting to call it CARES Act, but it's not CARES. You know, so the latest, and this is going to result in a direct allocation coming to the county in response. I'm still waiting on, you know, final confirmed numbers, but it looks like the estimates and the numbers that have been released in various sources is $20.77 million. And the distribution is going to come directly from the U.S. Treasury to the county. I'm anticipating, I don't know what the timing is, but we'll have an agreement that'll be released first before any funds are released. So that'll be coming before the board. And the distribution, it looks like it's going to be 50%. It's going to 50% is going to be released upon execution of an agreement with the U.S. Treasury, and then the remaining 50% would be released 12 months later. This is just some really preliminary information that I've got, but I think this is a large enough dollar amount that, you know, it's going to probably require, depending on the timing of the receipt of the funds, it's going to probably require some action taken this year if we want to have any funds that are being released this current budget year readily available to expend. We're going to have to, I'm currently looking at the whole process for getting that set up, and that may require a supplemental budget for this budget year. But then also the other amounts and whatever's not spent this fiscal year will have to be built into the 21-22 budget moving forward. And I know that the commissioners have already been, you know, there's been emails kind of being circulated and proposals, and I can just tell from the number of sales calls or emails that I'm getting from various vendors. You know, a lot of people know that counties and local municipalities are going to be getting these direct allocations in response to COVID and COVID recovery. And I just wanted to, you know, I'm still reviewing all the various legislation. I mean, it was just signed today. I'm looking, you know, through my sources and coming up with a plan on how, you know, to make sure that the budget, that we have full appropriation, but then keeping in mind that we'll probably want to schedule some work sessions in the near future to talk about how those funds are going to be utilized and what we're going to want to make available. And I thought, you know, I know that we had a really long session, but I just wanted to go on record for this meeting and just give you a heads up that the latest information and some of my notes just really quickly.
Thank you. Appreciate that. Yes, it's going to be good to get that that discussion underway. All right. So no other further announcements. We are going to go ahead and adjourn the meeting, knowing that we're going to reopen our meeting for the Extension Service District. So we'll thank you all for your time today, and we'll see you right back here.
And we have a link, correct?
Correct.
Thank you, Carrie, for sending me that little note.
Yes, thank you, Carrie.
I looked everywhere. I was like, oh my goodness, I don't see it.
I'm glad I wasn't the only one. Where in the world?
All right.
Are we ready to go?
Yes, we are.
Okay. I am, as the chair, I'm calling to order the Yamhill County Extension Service District Board of Directors meeting on the 11th day of March. And I believe we have all members here ready to go. So the first item on the agenda is consideration of adopting a board order formally stating the Extension Service District's opt-in, opt-out decision regarding the City of Newburgh's vertical housing development zone.
Ken?
And
Oh,
if
sorry.
I was just going to quickly say, Kelly and Rich had another scheduling appointment and with running long, but again, it's a good thing we had his comments during the formal session, but they also sent an email earlier in the process and advised that they're okay with opting in.
Thank you. Do I have a motion to approve opting in to Newburgh vertical housing?
So moved.
Okay, we have a motion on the floor. Those in favor?
Aye.
Aye.
And it looks like motion is approved to opt into the vertical housing development zone. Any other business? Nope. Okay. So I guess we will adjourn this meeting.
Thank you.
Thank you so much.
Thank you, everybody.